Hey, good morning, good afternoon, good evening, good night, wherever you are, whatever you're doing. It's me, Legal Vices, and welcome to the stream. Today, we've got a lot of stuff to get through. Well, actually, we have two things to get through, but a lot of stuff to discuss about those two things. How are we all doing today? It is a fantastically chill evening here in Busan, South Korea, 9:04 p.m. And it's getting windy because there's another typhoon blowing in the general direction of here. It's still no clear idea on exactly when it will be in the neighborhood or if it's going to completely shift out of the neighborhood, but we've still got a few days to worry about that. I'm just happy to be here with you on a wonderful Tuesday. Coming off a long 4-day holiday here in Korea. It was good to get back into the office and start doing some things. And it's great to be here with you all tonight. Mods, welcome. I see we have a plethora of mods here. And by plethora, Beaver, nice to see you. Long time no see, Rose. We've got Alan. And is that all of our mods we've got here today? Hey, that's a good start. And we've got all of you. We've got 66 people here right now. That is fantastic. 37 likes, so we're off to a good start. But come on, now we got to get about half of you. Get the other half. You just get down there, hit that like button, so I don't have to keep talking about this shit all night long. All right. What do we got going on today? Today, we are going to be looking at updates in the Taylor Schabusiness case and the lawsuit that was filed against Nirvana that a lot of people, dare I say most people, aren't even aware of. But it's a pretty interesting case, and that's what we're going to be talking about today. Tomorrow, just right off the bat, tomorrow you do not want to miss. Tomorrow, you be here, bring your friends, bring your neighbors, bring your family. Tomorrow is going to be one hell of a fun day. Why is it going to be one hell of a fun day? Because we are talking about some Australian folk heroes, outlaw folk heroes. I know we've got some Aussies here in the audience, so you'll know all about these cats. We're going to talk about them. And hey, as guests, I'm bringing on real live Aussies. That is correct. We are going to be talking about two major criminals in Australian history, an old one and a new one, that have reached hero status, outlaw heroes. And maybe in the future we'll be doing some Western for some guys out in America, out west, out around my hometown, like Butch Cassidy and the Sundance Kids and things like that. But these are going to be two Australian criminals that all Australians know, and it seems like most of them love. We're going to be talking about Ned Kelly, the original Iron Man. Ned Kelly was a badass. He was getting into some serious crap. This is late 1800s. He was getting into some serious crap when he was 14 years old, and he didn't stop until he was captured and hung. We are going to be talking about Ned Kelly. Ned Kelly, the original Iron Man. Why is he the original Iron Man? Dude and his gang built these 95 or 97 pound body armor, bulletproof body armor. So that's about 42 kilograms of just solid metal body armor. And they went on a damn crime spree. So that's the original Iron Man. We're going to be talking about Ned Kelly. They have museums, they have statues. He's a part of the culture. I mean, it's a huge story. And then we're also going to be talking about Chopper Reed. Chopper Reed is a great story. If you want to do some homework on that before tomorrow night, watch a movie from early 2000s with a very, very young Eric Bana. So that's where you got to start, playing Chopper in the movie Chopper. But we're going to be talking about the real Chopper Reed, who hurt a lot of people. Depending on what time you ask him, he either killed dozens and dozens of people, or he later in life narrowed it down to 17 to 19, and then maybe like 4 to 7-ish. But on his deathbed, he gave a deathbed interview and swore that it was only 4 people he killed. But he tortured many, many, many people. I mean, horrifically tortured them. And he was tortured himself. I mean, his friends would cross him. He'd shoot his friends. He got in arguments with his friends. His friends stabbed him. and they were still friends. We'll be talking a little bit about a man by the name of Neville Bartos, for example, who was a good friend of his, I guess, crossed him. He shot him in the leg and then felt so bad for him that he carried him off to the hospital. And later in life, they toured doing comedy shows together. That's how badass Chopper Read is. But Chopper Read was he was very much Dexter-like. He would say that he only went after drug dealers, criminals, and other low-life scumbags. So he is sort of the Australian Robin Hood. So you do not want to miss tomorrow. Tomorrow is going to be epic. We're going to be having who are we having? We're having the Law Patrol. But he's changed his channel to Overlord, I believe, right now, and Meme Copium. And we're also going to be having, who are we going to be having? Come on. I told you yesterday. Come on. Who are we having? Madcore Mofo. That's who we're going to be having on. We're going to be having on 3 internet Aussie heroes. Madcore Mofo, Meme Copium, and Law Patrol, formerly known as Law Patrol, now known as Overlord, to talk about Aussie outlaw heroes. Thursday, the defense are going to start their O.J. Simpson arguments. We're going to go through the first couple of hours of that. And then Friday, we've decided what we're going to do. I've talked to Farron. I will be on Farron's channel on Friday night U.S. time, which is Saturday morning my time. So I will still do my Friday night stream, which would be Friday morning U.S. time. And I'm just going to do a dump, just a story dump. All kinds of minor legal things, some weird stories, just some basic stuff for me to rant about. And hopefully, as part of the guest show, we will have Legal Mindset on with me to do a little bit of a joint rant. So look for me on Friday night, Korea time, Friday morning U.S. time, and possibly Legal Mindset joining as well. Then late Friday night U.S. time, I'll be on with Farron, and we'll be doing our Unexplained. We'll let her tell you what the topic is this time. So we're going to be having fun. So that's the week in advance. But for just by all that's holy, do not miss tomorrow night. That is going to be a lot of fun. If you pop on over to my Twitter, The Legal Vices, you'll see a little bit of a preview. Let me bring this up real quick. I'll just give you I'm way more excited than I should be about tomorrow. Chopper Read has been like a hero of mine ever since I saw the Eric Bana movie, and just reading about Ned Kelly over the past couple of weeks. It's pretty darn good. Here's our boys. Let's see if we can this is one of these weird things that if you click on it, it just makes it smaller. But yeah, there's our boys Chopper Read over here. Badass on the right. We have Ned Kelly. That's a replication of his armor. We'll be showing his actual armor on the stream tomorrow. But so yeah, that's the boys. That's who we're going to be looking at tomorrow. But today is Nirvana and Taylor Schabusiness Day. We've always been pronouncing her name Taylor Schabusiness, but from the horse's own mouth, so to speak, it's Schabusiness. So before we get into that, we have to do the usual grifting. We got 141 of you here and 74 likes. That means half of you haven't done your job. Please do me a favor and get on down there and hit that like button. Subscribe if you haven't already done so. That would be a great, great pleasure to me. It would bring the numbers up and let YouTube know we're here. And if you have subscribed, make sure you're still subscribed. They keep doing this. I keep hearing from you people saying that you were unsubscribed from my channel by YouTube through no fault of your own. So just double check and make sure you're there. And we have a memberships with three tiers. We have some pretty cute little fun little nice little emojis you can all use. We have some members only pictures. We'll be doing some members only streams and things, whatnot coming up. So do that. And tonight, as always, I try to focus on the stream, on the chat that's going on, because I have the best damn chat on the internet. Can't always keep up with the comments and questions that are going on there, especially tonight where I'm going to be doing a lot of reading and a lot of focusing on what's happening on the other screen. So if there's something you absolutely want to ask, any question at all, anything you want to say, anything you want to guarantee is seen, answered, and or responded to, super chats are the way to go. Not required, no minimum required. That's just there as an option for you to make sure that you get your question answered or comments read. Or if you just want to be a super awesome person and support me, that would be great. With that out of the way, it's time to jump into this. We need to decide where we're going to start, though. We're going to start with Taylor Schabusiness. Definitely starting with her. I don't know how many of you have seen the original Taylor Schabusiness things, though. She is a character, so I don't know if we need to go back and talk a little bit about her case, give some of the horrifically gory details. And just by the way, I'm going to just say right now, there's a general trigger warning going out for this entire show. Schabusiness gets into some really, really messy details of dismemberment, and the Nirvana case involves lots and lots of SVSA map stuff, proselyte, the trafficking of people under the age of 18. This show is going to be nowhere near being monetized. So, we'll just start there. Now, Taylor Schabusiness. This lady is an absolute piece of work. I'm going to Beaver's unit she's got it covered. It's a gory case. What I will do is I will bring up the criminal complaint against her, and we can talk a little bit about this. We'll just kind of hit the highlights. It's a long thing, and it's pretty repetitive and, quite frankly, pretty graphic. She has been charged with first-degree intentional homicide in Wisconsin. Wisconsin has some problems. I don't know what y'all are doing up there in Wisconsin, but you're all insane. That's where, we've got Rittenhouse, we've got Chandler, the other dismemberer. We've got her. There's just all kinds of whack stuff going on. Is whack? Do kids still say whack? Is that still a thing? There is lots of things going on there now, and Teresa Ferry is just spoiling everything. Spoiler alert! Don't read the chat. She'd been charged with first-degree intentional homicide as a repeater, not a repeat in first-degree intentional homicide, just a repeat in things involving assault. She's accused with causing the death of the victim, who's her boyfriend, with intent to kill that person, and upon conviction shall be sentenced to imprisonment for life. In Wisconsin, as far as I know, there is no death penalty, and if you are found guilty of first-degree intentional homicide, it is life in prison without the possibility of parole. Do not pass go. Do not collect $200. But they're going to give her an extra 6 years, life imprisonment plus 6 years, because the defendant is a repeater, having been convicted of battery or threat to a judge, prosecutor, or law enforcement officer. So great. She's a fine, upstanding citizen. Not only has she whacked her boyfriend, she has assaulted a judge or a police officer or a prosecutor at some point in her past, plus mutilating a corpse with the same repeater offense. So she's got life. She's facing life plus 6 years, plus a 12 more years and 6 months, and or a fine of $25,000 for dismembering a corpse with intent to conceal a crime. And because she has this previous history of assaulting a judge, prosecutor, or law enforcement officer, the maximum term of imprisonment can be increased. And third-degree SA as a repeater. This is where we start getting into some gory details. The above-named defendant did have intercourse with the victim without that person's consent after he was dead. That's part of the story. It wasn't, but he was after he was dead. Yeah. So that gets her 10 years or a fine, plus the previous assault conviction gets her some extra time. So quick story here. We'll just read the first part of the probable cause here, so you can kind of get an idea of what sort of character we're looking at if you're not aware of who she is and what she has done. The judge has read this, the complaint. Here we go. They were dispatched to this residence in Green Bay, Brown County, Wisconsin, for a report of a severed head being found in a bucket in the basement. Once he reached the bottom of the stairs, Officer Wanish observed the plastic bucket on the floor, observed a shower beach towel over the bucket. He lifted the towel and observed a human head inside the bucket. He looked around the room and observed what appeared to be dried blood on a nearby mattress. What apparently happened, and when the police pretty quickly figured out who the main suspect was, her. So they went to her house, and when the police got here, they asked her the question, "Do you know why?" And this is all it comes later here in this lovely document. They all ask her, "Do you know why we're here?" And she says, "Oh, yeah." And then she begins to talk. And this whole time she's still covered with blood. Not the sharpest tool in the shed, so to speak. Here. Officer Russell saw Schabusiness emerge from the apartment building, and upon seeing officers, she stopped. Officer Russell could see that Schabusiness had what appeared to be dried blood on the front of her black hooded sweatshirt, as well as her black sweatpants. Officer Russell later found Schabusiness's hands appeared to be smeared with blood as well, and there's also what appeared to be dried blood on the back of her sweatshirt. Officer Russell asked Schabusiness if she knew why the officers were there, and she stated something that sounded like, "Because of my warrant for my arrest?" Well, congratulations, Schabusiness, you win. She basically goes to the police station and tells them that they were doing drugs together. I can't remember what was in the this massive drug cocktail. It's things that are never, ever, ever meant to be together. But they did this cocktail of drugs together after smoking some weed. They went down to the basement to play. Apparently both of them were into S&M a little bit, and it was time for him. I guess he volunteered to be the sub at the beginning. So she wrapped a chain around his neck and started choking him out while they were enjoying their little love play here. Trying to hide as much of this as we can. It's pretty graphic all the way through. And so she blacks out while she's choking him out. She comes to, and well, I guess we can just get rid of this whole thing right now. So she comes to in the middle of choking him out with the chain, and she was telling the police when they were saying, "Well, why did you do this then?" She was telling the police things like, "Well, I'd already gone that far, so I just decided to see what would happen." And saying things like, have you ever loved something so much that you wanted to kill and destroy it? Basically she just said she saw she was already choking him halfway out, so she may as well continue. So she completed the job. I can't remember what the drug cocktail was. So what's asking, but I mean, it was a lot of stuff. See if I can quickly find it here. They smoked some marijuana. She left the victim, smoked some methamphetamine. Schabusiness friend left. Schabusiness reported then shot himself up, the victim, with trazodone. Okay, yeah. So they did marijuana, meth, and trazodone. That's pretty nice. Then this is her telling cops. She began to choke the victim. He was face down, started coughing up blood, waiting for him to die. And she said, "Yeah, I liked it," is what she told the police. Detective Kemp clarified that Schabusiness began to cough up blood. She just kept on choking it because she wanted to see what happens. She made comments as she blacked out while choking the victim, but when she woke up, the victim was already purple, so she kept going. They knew if she asked the police if they knew what it was like to love someone so much that you kill it. So this was going on through the whole thing, and she could feel the victim's heartbeat. I mean, it's a pretty graphic story here, but we will get to the gist of the story. Is after he died, she went through about 6 or 7 kitchen knives trying to dismember him. She took part of him out and put it in her roommate's car. I'm sure the roommate was pretty thrilled about that. She told the again, let me see if I can quickly breeze through. She told the police something like, "Good luck finding all of the pieces of him." She mentioned something about like a puzzle. It's like he's a puzzle. Good luck finding all of his organs or some crap like that. I mean, she did a number on him, really. Schabusiness responded that the police were going to have fun trying to find all of the organs as she dismembered the body. She stated all of the body parts should be in the basement and there should be a foot or a leg in the minivan. Charming. And well, she decided it was time to leave the house in the middle of trying to hide the body. And she, before she left the house, she took a dildo and played with the corpse of her boyfriend. Then she played with her ex corpse boyfriend's member. Then she severed his member along with other body parts and pleasured herself with his severed member for about 3 hours. Then she decided it was time to leave. Then she then of course she left this bucket with a head and his member in it at the bottom of the stairs covered with a blanket. Mom heard the back door slam, went downstairs, and that's what she found. She found her son's head and member in the bucket and the blood all over the place. And this again was part of her statement to the police. Detective Groff asked Schabusiness questions about her using ST's her roommate's minivan, and asked if she and the victim had contact with anybody when they first got to the house, back to the house. Schabusiness then made the statement, "Damn, the head. I can't believe I left the head though." So, yeah, that's the kind of person we're dealing with here. And why? And when she's telling the police, she's correcting the police because the police report said one thing. They go through their police report to double check the stories, and she's actually correcting the police officers at some point along the way, telling them what really happened. So why is she going? Why isn't she pleading guilty? Well, why wasn't she pleading guilty? She wasn't she has nothing to lose. It was the same with Chandler Halderson. If you plead guilty, you just go straight to jail for the rest of your natural born life. If you plead not guilty, you have a Hail Mary of a chance of something going seriously wrong with the prosecution and getting an acquittal or getting a mistrial or something, just anything to keep you out of prison for the rest of your life for the time being. So she pled not guilty. And well, she didn't even get that far, actually. She was going in for her arraignment, and her public defender lawyer said, "I think we need to have a mental evaluation." Because she wasn't cooperating with the defense. I think we need a mental evaluation. So the judge assigned a psychiatrist or psychologist to do the mental exam. And the results came back and found her fit to stand trial. The public defender said, "Well, we'd like a second opinion." The judge said, "Well, no, we're not going to waste the taxpayers' money. We're not going to waste the time. But if you want to use your own dime to get a second opinion, be my guest." So that's what the public defender did. They went out and got a second opinion on their own dime, their own psychiatrist. And I mean, you can find an expert to pretty much say anything you want. But even their psychiatrist or their evaluator had to come back and say she's fit to stand trial. They couldn't even pay someone enough to come up with an opinion that was useful to their client. So the judge said, "We're going to go ahead with the arraignment." And then she pled not guilty. She pled not guilty, and there was a trial that was, there was a hearing that was supposed to be scheduled for September 1st. That's when they were going to do the trial was supposed to start on September 20th, no, October 20th, I believe. Or is it September 20th? I can't remember. September 20th or October 20th. October 20th is when it was supposed to start. They were going to have a status hearing, which just means how are we going? Are we well on our way to being ready for trial? Do we keep the trial date or do we move it? But she changed her plea. Let's bring up the news story. Da-da-da. This is an article titled Green Bay dismemberment case. Trial for Taylor Schabusiness delayed. The trial for a woman accused of killing, that's our lovely defendant there. The trial for a woman accused of killing and dismembering a Green Bay man has been delayed following a hearing Thursday. Taylor Schabusiness appeared in court for a status conference Thursday. Her lawyer said that their case wouldn't be ready by the October date when the jury was slated to begin. During Thursday's hearing, the lawyer for Schabusiness asked for a new status hearing for a new trial date. Online records state the original jury trial set for next month was removed from the court's calendar. Schabusiness plans to plead not guilty by insanity. The judge is appointing an evaluator because of the planned plea. Additionally, the attorney for the estate told the judge Thursday that the state is waiting on an autopsy report. Which part? Schabusiness is charged with first-degree intentional homicide, mutilating a corpse, third-degree SA. Schabusiness is accused of killing Shad Thyrion, who was found dismembered in February at a Green Bay home. Another status hearing is slated for October 3rd. So this is the last time you're going to be hearing about Taylor Schabusiness until October 3rd, at least, when we figure out what's going on. We have a super chat to get through. Flux starting us off in the super chat alley. Thank you so much. You know, I'm really grateful for Amber Turd. Because of her, we got you. Flux, that's so sweet of you. Thank you so much. Dang. We got you. Lol, I love this community and chat. Y'all are great. I'm only sad that this isn't like a comedy club where we can all meet for real. Yeah. That'd be wild if I get all of you in my chat in one place at one time. That would be pretty awesome. But thank you so much for that super chat. That is deeply, deeply appreciated. And y'all can super chat as much as you like to get your statements out there, read and answered and responded to. So what does this look like? What's happening now? What does this not guilty by reason of insanity mean? I mean, that's just one of the you can say you can plead guilty but insane. I don't know if that's a thing in Wisconsin, or you can plead not guilty by reason of insanity. I guess if you were going to just look generally at what the difference between those are very randomly and not any sort of legal definition, would be that guilty but insane. I did it, but I shouldn't be held responsible for it because I'm insane. And that's not anything. There's all the post conviction stuff with that. You just start out with the premise that you did it. Now here it's not guilty by reason of insanity, which is very similar, but very subtle differences. Pin trigger warning to cover your members. Yeah, member, I know. I just it says my Beavers unit. Thanks. Anyway, what we've got with not guilty by reason of insanity means that, as I understand it, I mean, Wisconsin may be different, is that if she's found, if first of all, they find, did she do it? Then they go, okay, was she insane? We're guilty but insane. You just skip the whole did she do it thing. It may start with a presumption. We'll just have to see as more details come out about how this pleading actually works, and we'll probably see more of that in October. But basically, this is the evaluation. She gets a third evaluation. When you apparently in Wisconsin, when you plead not guilty by reason of insanity, that automatically triggers another evaluation. So she's going to be evaluated again to see whether she's fit for trial, and then they'll start the arguments. It'll probably be delayed until next year, the trial, I would guess now. Once that it's been on the docket for a while, and it's probably filled up through at least the end of the year. So I would guess, unfortunately, she's not going to trial next month. I would guess mid 2023, perhaps late 2023. Yeah. So alas, until the next status hearing, which probably will involve the results of the newest evaluation number 3, until then, that's end of the Schabusiness. And I thought we'd go out with just hearing a little bit of something, from the lovely lady herself. She's grifting. This is her prison plea. She's got to get her swole on. She's got to get to her commissary. And watching this is when I learned how she pronounces her name. This is our little sweetheart here. And what do you have to say for yourself, Shaw?
Hi, I'm Taylor Schabusiness, and I'm a very hardworking, dedicated individual that's broke and really needs money to help get that swole on. So if you could please donate to this GoFundMe page, be greatly appreciated. Thank you.
There we go. All righty. That's our lady. Don't do drugs. Don't sacrifice your loved ones. Stay out of prison. Yeah, I know you keep saying pin the trigger warning. Well, there's a lot of things that have to go into that. We're done talking about that. So now we're moving on to lawsuits. I don't think we really need to pin it, but thank you so much for the suggest. We're doing good. My member is covered. My members are covered with the blanket thing. So, yeah, we've got things to move on to. That's kind of a hard one to segue out of. But now let's talk about some light, happy stuff. Let's talk about Nirvana. Now, this doesn't get into any real details about SA or SV or anything like that. It's just one goofball making a lot of really goofy statements that involve those words. I don't know how many of you are familiar with this lawsuit. My beaver's gonna ask, what is a swole? A swole is that's kind of like go watch like some of the old prison shows and things on Netflix and YouTube. It's kind of everybody chips in a little bit, and you make like big burritos or big salads or big meals, whatever. You got to contribute something. It's basically prison cooking more than just like it's the extra commissarial prison cooking. So yeah, she needs some money on her commissary so she can get some good food. Well, I suggest you get used to it. All right. Moving right along. Let's talk about Nirvana music. We've all seen the cover of Nirvana, the Nevermind album, I assume, correct? Let me whip this up here. Where are we? I thought I had it tagged up, but I guess I didn't, because that's how I roll. Nirvana. Nirvana. Where are we at here? I've got so many things here. Yeah, all right. If you're not familiar with Nirvana's Nevermind album cover from 1991, was it? 1991, 1994, I forget. Well, it's mentioned in the lawsuit here. There we go. This album cover here with this little bounder. That's the album cover. Little boy, this dingleberry hanging out in the swimming pool, reaching for $1 on a fish hook. That album cover. Of course you like that album cover, Joe Choi. That was a good album. Even for an old man of the 80s, 70s, and 80s like me, that was a good album. Well, turns out, boy in the picture wants to get paid. So he filed a lawsuit against pretty much everybody that had anything to do with anything. And that's what we're going to talk about for the remainder of the show today. Hey, Brandon Lesko, thank you so much for the super chat. What a time to join. Did you luckily miss the Schabusiness part, or were you here for that? Oh, and if you're asking, yes, I do have the official Johnny Depp Mega Pint Legal Vices Pimp Cup in action tonight, and it actually has wine in it. It is a delicious 10-year tawny port wine. Why tawny port? Because it's 20% alcohol. Welcome aboard, Brandon. Good to have you here. Aha. Good. You just joined in time to see the baby dong. Well, good. You missed the recap of the Taylor Schabusiness business. Mr. Upper Torso, stand by. So I think it's more than just being paid. I think he's trying to say he was exploited when underage. Now he's saying that those pictures exploited him when he was underage, so now he wants to get paid. We're going to be talking about this. And let me bring up the first in a lovely line of documents that we'll be looking at this evening involving him and his lawsuit against everybody that ever had anything to do with that album. Boop. All right. Now, there's going to be, all right, I'm going to try not to boomer this. We know my track record with boomering this stuff is really, really bad when I cover up the screen here. There we go. Some background before we get to this particular document. What we've got is he files this lawsuit alleging all kinds of horrible things. And then he against a bunch of people. Then he goes and amends it. He files a first amended complaint where he just amends a few details in the lawsuit and then refiles it, basically. Now, we're going to pick this up after the amended complaint is filed. So we don't really need to go through his complaint itself because there's enough of the original lawsuit of the complaint in this motion that we're going to look at first to give you the idea of what it is that he is claiming. So let's go through this here. Let me bring up my adjustable screen. Hope that's good enough and big enough for everybody to see. Let me organize it here just slightly better. And all right, I'm going into reading mode now. So hey, super chat. This is Spelden Enser. This is Spencer Eldon, the boy in the swimming pool, versus Nirvana LLC et al., which means and others. Brandon, let's go. First time I got drunk, it was on a nice tawny port and expensive champagne. Nice. My mom was disappointed we were drinking so young. Dad was really pissed we wasted his good stuff. That is understandable. This is a Graham's 10-year tawny port, which is fantastic. The only thing better than Graham's 10-year tawny port is Graham's 20-year tawny port. But I'm not a big wine guy, and I'm not about to spend $100 on a bottle of wine unless I have to. But the 20% is nice. Thank you for the super chat, Brendan. Deeply appreciated it. Let's go. So we've got, did I do? Oh, good. I brought the screen up. I didn't boomer out. Against Nirvana LLC and others. Well, these others are a long list. Flocks, let me read here. Thank you so much. Yes, the screen is big enough for us to see, unlike this little dingle. Well, yeah. Dude's crazy enough. I don't want to get sued. So we censored it. Thank you, Flocks, for that helpful and insightful comment. Don't know where I'd be without you. Just kidding. All right. Here's a few of the defendants. Defendants: UMG Recordings Inc., Universal Music Group Inc., the David Geffen Company, Geffen Records, MCA Records, Nirvana LLC, Kurt Cobain, deceased, Courtney Love as executor of the estate of Kurt Cobain, Chris Novoselic, David Grohl, Kirk Weddle, he was a photographer, collectively the defendants. They'll move the court pursuant to Federal Rule of Civil Procedure. This is a 12B6 is a motion to dismiss. And this is the defendant. These are the defendants that are making it. They got the complaint And then they got the first amended complaint, and now they're just saying, all right, we have to make a motion to dismiss. And it's very, very difficult to get a motion to dismiss granted. You saw both Amber Heard and Johnny Depp try it most recently. It's just something you have to do. But this case, it goes a little bit more seriously. Now, here's the grounds for their motion to dismiss. They brought up all of these illegal things that they claim that all of these defendants did. And here the defendants are responding to it. So the first cause of action for violation of the federal child pornography statute is barred by the applicable statute of limitations. Well, we'll just call it CP. The CP statute is barred because of time limitation. You waited too long, pal. You waited too long to file your lawsuit. The statute of limitations has expired. The second cause for action, alleged violation of the federal trafficking of children statute, cannot be sustained because the alleged trafficking occurred before the enactment of a civil cause of action, and the claim is also barred by the applicable statute of limitations. What they're saying here is there was a new law between the time the picture was taken and the time that he brought the lawsuit. There was a new law that was instituted, that was enacted to allow victims of child trafficking to claim civil damages against their trafficker. And they're saying that he can't bring his claims under that act because the act didn't exist when the album was made. And even if he could, it's time barred because he waited too long. So accordingly, the motion for dismissal should be granted with prejudice. With prejudice means you should not be allowed to file it again. Without prejudice, if something is dismissed without prejudice, that means you can file the lawsuit again. So here he's saying both of them are time barred. Both of them you waited too long, and one of them it wasn't even something you could sue for when it happened. Allegedly happened, I guess I should say. Now, here we go through a long laundry list of these are cases that are cited in their motion. These are statutes that are cited. And this is their introduction. This dispute is based in part on the claims. So we can hear a little bit of what it was the guy was alleging was going on. And this motion, as we go through these motions, you'll notice that like the defense are getting snarkier and snarkier and snarkier as we go through these things here. This reads like a good Ben Chew brief or comment in the Amber Heard Johnny Depp trials, because he made some pretty biting and snarky comments to Elaine and company. This reads a lot like that. There's just a lot of funny words and funny phrases in here that just show how much disdain the defense has for this particular kid. Well, I guess he's not a kid now, he's in his 30s. So here we go. This is the introduction. This dispute concerns one of the most famous photographs of all time. The cover art for the rock album Nevermind by Nirvana, released in 1991, shows the photograph of an unclothed baby floating in a swimming pool while a dollar bill dangles from a fishhook in the foreground. The photograph evokes themes of greed, innocence, and a motif of the cherub in Western art. Tens of millions of albums, t-shirts, everything's been sold. Now the plaintiff in the action says that this world famous, widely possessed photograph is CP. The photograph was taken and released in 1991. The baby in the photograph is now a 30-year-old man. The plaintiff, Spencer Eldon. Eldon has spent 3 decades. This is where they just start to unleash on the guy. Like the second paragraph, they just start to unleash on what a bunch of bullshit this lawsuit is. Eldon has spent 3 decades profiting from his celebrity as the self-anointed Nirvana baby. Mr. Upper Torso, lol, anyone who owned the album is going to jail according to this lawsuit. Oh, wait. That actually comes up. That actually comes up. Just hold your horses, partner. He has reenacted the photograph in exchange for a fee many times. He has had the album title Nevermind tattooed across his chest. He has appeared on a talk show wearing a self-parodying nude-colored onesie. He has autographed copies of the album cover for sale on eBay. He has used the connection to try to pick up women. Now he's coming and saying, oh, I was exploited. I was damaged. I suffered all of these damages throughout my life. When they, just in one paragraph, they have crushed him. They've just devastated him with all of this. He is the one that's grifting off of this. He has used his connection to try to pick up women. Oh, wait till we get to that part. That's really, really, really just icky. They quote his pickup lines. Spoiler alert, they're really bad pickup lines. Yes, Mr. Upper Torso again, and they says a naked body isn't within itself porno. The intention, the vibe, and so many other things. Got to be extra careful with kids so they're happy and comfy with any work, or predatory out of the gate. But are predatory. Yeah, I mean, again, this is all stuff that's coming. Yes, settle down there. We're getting there. Eldon's claim that the photograph on the Nevermind album cover is CP is on its face not serious. That is as close as you can come in a legal document to be saying, you got to be fucking kidding me. This can't possibly be a serious argument. That's as close as you can come to that. A brief examination of the photograph or Eldon's own conduct, not to mention the photograph's presence in the homes of millions of Americans who, on Eldon's theory, are guilty of felony possession of child pee, makes that clear. So, yep, on Eldon's theory, anyone that has that album, that cassette, a copy of it on their phone with a graphic image of it is guilty of felony possession of CP. Yeah. And again, as Mr. Upper Torso was saying, no one seriously could think that a Renoir painting of a nude woman or an innocuous family snapshot of a naked child in a bathtub violates the CP laws. Nudity must be coupled with other circumstances that make the visual depiction lascivious or sexually provocative in order to fall within the parameters of the CP statute. Another phrase that people like to use is prurient interests. So then they just say, there's no doubt that Eldon's claim will fail on the merits if it goes to trial. If we go to trial, there's no doubt he's going to lose on this. He says, rather, it addresses a separate problem. He said, okay, this motion doesn't talk about the merits. We're not even going to go talk about how ludicrous those arguments are because we don't need to talk about how ludicrous those arguments are. Why? Because he waited too long. He says, rather, it addresses a separate problem. Eldon's claims fail at the outset because they're time barred. And speaking of time bar, I want to get we already got Flux in there. Sorry. I thought sorry about that. Oh, good. Well, great. I mistakenly read one Flux thing, but that's great because you just happened to serendipitously read my mind and super chat another question. Could they make an album cover like this today and get away with it? I doubt it. I mean, legally they could get away with it. Socially, probably not. Which is why any of you out there that have pictures of your children in bathtubs or running through sprinklers or your baby girl's topless running around the yard, you are completely crazy for doing that. There's way too many sick people in the world, way too many Karens in the world. Don't put pictures of your baby's bits and pieces on the internet. Don't even put them on your phone if you don't have to. It's just not a good thing to do because you never know who's going to accuse you of what and how someone is going to interpret it. It's sad that this is where we are in society, but that's kind of the truth. That's just where we are. Someone might see that. Someone might accuse you of something and of doing something you didn't do, or may misconstrue it, and a jury may agree with that person. It's dangerous, dangerous, dangerous. Now that I've got that rant out of the way, let me take another drink. Delicious. All right. Eldon asserts two causes of action. Let me get this here. Two causes of action, one under the federal statute that permits victims of certain federal CP criminal offenses to sue for civil damages. That's one we just talked about. And another under the federal statute that permits victims of certain trafficking crimes. So certain CP victims and certain traffic crimes. Both of those acts allow people to sue for civil damages. And then the crushing sentence, neither cause of action is timely. In other words, you waited. The first claim has a 10-year limitation period and cannot reach an injury that Eldon knew about before 2011. So that's just essentially saying he has 10 years to bring the claim. 10 years ago was 2011. So anything that happened or occurred before 2011, he can't claim. It's time barred, is too late. He lost his chance. Anything after 2011 is fair game still. But, well, here the complaint was filed on August 24th, 2021, meaning that 10 years before the date of filing is August 24th, 2011. This means that for a claim to lie, Eldon must have discovered the supposed violation or injury after August 2011. But the Nevermind cover photograph was taken in 1991. It was world famous by no later than 1992 and long before 2011. Brandon Lesko asks, can you say goober on YouTube? I don't know if you can say goober on YouTube, but I'm not going to. You can't trick me like that. You can't get me like that, Brandon. I'm smarter than you. Yeah, so basically, all this shit went down a long time before 2011, August 24. And if it happened before then, you're S-O-L, Eldon. You're S-O-Eldon. And then they say he didn't file his lawsuit correctly. Renovation has a good question. Legal Vices, what is Renovation's question? Renovatio. Could it not be said that as a child on the date of August 24, 2011, he was not in a position to file a claim? That comes up later. He's 30 years old, so 10 years ago he was 20. He was already an adult on August 24th, 2011. But there's also other reasons. We'll get into it a little bit later. There's 3 ways that you can get around that time bar, and they pretty much crush every one of those. So yeah, that's a good question. But he was an adult on August 24th, 2011. He was 20 years old. Next. Oh, while we're at it, real quickly here, a series of bats. Cool, Nick. Is that a skull or an ood, or what is that in your Nick? Okay. Somewhere there exists a picture of me as an unclothed baby sitting in a giant cooking pot. There might be a similar one somewhere in the ether. I don't think it was ever put online, but I know in a shoebox somewhere in a storage unit. There's picture of me and my sister. I think we were sitting in a big pot. I can't remember. Anyway, that was the thing back when I was a kid, back there in the late 60s and early 70s. It was just, let's take pictures of bits and pieces. And in Korea, that was a thing. That used to be a thing. Like when your baby, like on his first birthday, you would take a naked picture of him, like a full frontal picture of your male child, just so you can see he's a male, he's a man, he's gonna grow up to be a big boy. That was a thing, but I haven't seen that for a long, long, long time. Yeah. Well, so the next part is they argue that that his lawyers filed the claims incorrectly. They didn't do it right. I said you have to plead this issue in a certain way. You have to identify each defendant and what they specifically did themselves to violate the law that would allow you to claim against them. So that he's saying they didn't do that. They didn't. He said he didn't specify the particular conduct by any defendant after 2011. So it's like if it happens after August 2011, you can do it, but you still, whether it's before or after, have to specify each individual defendant and exactly what they did wrong. It lumps all 11 defendants together in describing the alleged violations of the statute, even though for certain. Now follow this logic. This is great. This is another snarky moment that just is kind of like a punch in the gut. It lumps all 11 defendants together in describing the alleged violations of the statute, even though for certain defendants, there is no possible post-2011 violation. Even though he's just saying that everybody did exactly the same thing, but that's completely impossible for some of the defendants to have done anything after 2011. Why is it impossible for some of the defendants to have done anything in the last 10 years to cause this? Well, because Kurt Cobain died in 1994. You're suing Kurt Cobain, and he died in 1994. So your claims are time barred. Anything post 2011, Kurt Cobain couldn't have been involved in because he wasn't around here to be involved in it. Oops. So yeah, you can't just take a shotgun approach and say anyone who ever even looked at this picture owes me money. But even if he had properly played, he didn't properly plead it because you didn't say what each one of these individual people did after 2011 to cause you damage. But even if you had done that, it doesn't matter because you still didn't file it in time. F Kurt? Oh, for Kurt. Okay. Okay, for Kurt, lol. Oh, again, a series of bats. Thank you so much again. My icon image is the skull of a horse that was shot in the head, found in Arkansas, wearing my top hat. Cool. It's my little hell pony. Oh, that's cool. Sort of looked like a Doctor Who ood or like a crow or a Skeksis from the Dark Crystal. But yeah, that's pretty cool. You didn't really have to super chat to do that, but thank you so much. Hey, the living Kurt. Hey, there is a living Kurt. Hey, living Kurt. Yeah, we're not talking about the living Kurt. We're talking about the night of the living Kurts here. The night of the living Kurt Cobain. Welcome, Kurt. Nice to see you here. Where were we? Oh yeah, we were talking about they're just, as Kurt would say, all the stupid is here in this particular claim. So we talked just a minute ago about how they created a statute that said that certain victims of trafficking could bring civil claims against their trafficker. Well, in addition to the CP claim, Eldon has alleged that the creation of the photograph for the album cover art entailed the trafficking of Eldon when he was a baby. Series of bad. Oh, we just did that one. What the hell's wrong with me? That's what I was going for. Brendan, thank you so much again. Do you have that great big-breasted shot glass handy? No, it's in the dishwasher. It's really terrific, very sexy, just a fantastic shot glass. I'm not going to read your chats for a while unless they're relevant. Other shot glasses, total disaster. You're right. Let's get back into the soddy details of this thing. Sodded and sordid details. So Eldon has alleged that the creation of the photograph for the album cover art entailed trafficking of Eldon when he was a baby. And again, here I just love how his lawyers, as this thing goes on, are getting snarkier and snarkier and snarkier. Setting aside that this premise is absurd, comma, the statute Eldon invokes to cover conduct in 1991 became effective on December 19th, 2003, and has no retroactive application to conduct by a defendant that predates its effective date. So basically, the law came into effect in 2003. This happened in 91. It's not retroactive, so it doesn't cover it. And not to mention, the premise is absurd, comma. Eldon has alleged no conduct by any defendant that could possibly constitute the trafficking of a child after the enactment of the law in 2003. And again, even if he could, it's time barred. He waited more than his 10 years. Thus, even assuming the claim could have existed prior to the enactment of the civil action, Eldon's claim expired 4 years from accrual in 1995. I guess it was 4 years, not 10 years. Okay. Yeah. So any claims that may have existed disappeared in 1995. The snark continues. Okay, and this is showing that he knew about this well before 2011 when the time bar is now, because like every day we move ahead, the time bar moves ahead. So January 1, 2021 and January 1, 2011. When it goes to January 2, that 10-year time limit moves up to January 2. So what he's saying is anything that happened 10 years before this lawsuit was filed, he knew about the damages well before 10 years previous to filing these charges. And this is some of the information. It's gone all over the world. Popularity, it was on the Billboard charts. And the cover was not only available online, but was during all relevant times widely distributed in physical format and continues to be distributed in various mediums to this day. Eldon contends this is his injuries he's suffered. Eldon contends that he has sustained injury from when he was a minor to the present day. You see, here's trying to be a little tricky, saying, yeah, the initial injury started maybe before the time period, but I'm still being injured today. The injury continues. He's trying to be a little tricky there, but we'll see how that goes. Eldon claims the Elden Ring. How come chat, I'm disappointed in you. How come none of you have made an Elden Ring joke? And how come I haven't thought of an Elden Ring until just right now? Damn it. I'm disappointed in you. I'm disappointed in me. Nobody has made an Elden Ring joke yet. Damn it. All right. Eldon claims that he has suffered from having his identity and legal name forever tied to the image of his commercial sexual exploitation as an infant, which was distributed and sold worldwide for over 30 years and continues to this day. On civil law, with all due respect, yeah, this lawsuit is dumb. It's dumb. We're all dumber for having heard it. It's all the dumb in one place. Sorry, Kurt. That's my best Kurt. That's my best Kurt impression. Eldon has only suffered from greed. All the greed in one basket. Okay. Legal Vices, send me a stream link. I want to mock this pile of stupid. Okay. Let's mock this pile of stupid together. Let me clear these super chats, and then I will send that to you momentarily. Do you have that? Oh, we already just did that one. Brandon, let's go. Objection. Relevance. Overruled, counselor. Thank you so much for that. And another $2 coming my way. Objection. Hearsay. Says Flux. Thank you, Flux, for that. And again, Flux, because the Elden Ring is terrible. No, it's not. It's a good game. All right. And I'm just saying because I'm now like 85 hours into it, and I still am just now barely getting an inkling of what's happening there. All righty, let's see. Just a moment. Unciviling myself. All righty. Link is away, Sir Kurt. You now have the link, and we will wait for the chime to let me know he's answering the door. Rose, mock this pile of stupid Kurt and Jeff with the boom. All right. Oh, here we go. All right. Oh, wait a minute. What did I do? All right, there we go. Let's sorry, I'm boomering this here. Hey, good morning, cowboy. How's it going?
Good morning. How are you, sir?
Pretty darn good. Got my fortified tawny port going. So
yeah. So this lawsuit is an incredible pile of stupid. It is insanely stupid. Eldon has decided that he likes money, and he has decided that maybe Nirvana has money and he'd like some of that money. This is nothing more than pure greed, and I'd like some money.
Well, it would probably be more of an argument than that if he hadn't essentially said that at one point in the lawsuit.
Yeah. He was kind of well aware of it. There were more than a few pictures of him with the album, celebrating the album. This guy is probably the guy who took the album with him to bars in order to try to pick up chicks. Hey, have you seen this album cover? I'm this guy.
Oh no, they've got his pickup lines. In one of the motions. The pickup lines are here. Oh yeah.
Are they in the motions? The pickup lines? Oh
yeah. And they're even worse.
I need to experience for my full joy. I was only speculating, but now we have evidence. Oh, fun.
Yeah. Well, here's his damages. His identity and legal name are forever tied to the image of his commercial sexual exploitation.
No one knows who you are.
As an infant. Yeah.
No one knows who you are. To this day, no one knows who you are. That's I don't even know if that's worse or not. You've been forgotten. No one knows you're the Nirvana baby. No one cares.
Let's do this. All right, here we go. And here's just a few examples of him knowing well before the statute of limitations came into play that he had been allegedly damaged. If he was so damaged throughout his life, he had plenty of time. In 2003, Eldon was 12 years old, gave his own interview in which he commented, every 5 years or so, someone's going to call me up and ask me about, well, never mind, and I'm probably going to make some money from it. Dun, dun, dun. Foreshadowing. In 2008, Eldon, then 17 years old, joked to MTV about using Nevermind-inspired pickup lines on girls such as, you want to see my penis? Again? How's that for a pickup line, ladies? Do you want to see my penis?
Why would I want to see that pathetic little thing?
I mean, God, even in my worst 17 or what was that? That was maybe 7. Yeah, even in my worst 17-year-old moment, I could come up with a better pickup line than want to see my penis again. Brendan Lesko was one, I'm a grower and not a shower. Nope, it was just want to see my penis again. Yeah. It seems like the ladies aren't buying that as a legit pickup line.
The pickup line, if it ever worked, has long since stopped working. The money that existed has long since rolling in. The fame that has existed once since. No one cares anymore about that you were the Nevermind baby. Now it's just, okay, that was interesting. It's probably his profile picture on all the dating apps.
I'm sure it was until this lawsuit. It probably still is, knowing him. In 2011, a 20-year-old Eldon shared in another interview, being the Nirvana baby was always a thing I grew up with and has helped get his foot in the door for a couple of situations, which is always handy. Yet it caused him so much damage that it helped him out a lot. It's kind of like being a secret porn star, but not really. But it's not even porn. It's more like a Farrah Fawcett poster. You remember the Farrah Fawcett poster, Kurt?
Sure.
I don't think that album cover was anything like the Farrah Fawcett poster.
Nope.
I think we need to look for the Farrah Fawcett poster.
Yes. we need to have this point of education. This is for educational purposes.
And this is like around, Well, I'm 53. My brother had the poster. He was 5 years older, so I would say anyone from 55 to what would you say 45? Kurt would be able to. You just say the Farrah Fawcett poster, and they know what you're talking about. I don't know what the lower age range would be, but yeah, this. All right, where are we? Yeah, we will bring this up right about here. Gotta kick that out. Bring this up. This is the Farrah Fawcett poster. That's nothing like the album cover. And every male, and I don't know what year this came out. It would have been what late 70s, early 80s. No, I don't think it was.
I was thinking early 80s.
Yeah, whenever Charlie's Angels was big on TV, but every male child had this either on his wall with cool parents or in his closet with uncool parents. Mine was taped on the inside of the back of the closet door, the sliding closet door. But yeah, he's saying no, it's not really porn. It's like the Farrah Fawcett. No, it's not. That's the Farrah Fawcett poster.
Well, I suppose it's like the Farrah Fawcett poster in so much as his image was as widely distributed. Nevermind was one of the most popular albums of all time and remains a great album for that matter. Yeah. So, I mean, his image might have been shared and looked at by as many people as the Farrah Fawcett poster. So I guess it's similar in that respect.
Because I would guess it'd be like the Farrah Fawcett poster and then the Daisy Duke poster with what's her name? The actress standing in front of the hay bales with the tied off teeth. Those were the big those were the big posters when I was a kid. But well, let's see more of his damages that he didn't suffer. Got to bring this back on up. Bring back on up to the east side. There we go. Well, he tells the Guardian later, it's always been a positive thing, an open door. If you're going to sue someone for millions of dollars of damages, make sure you're not on record as always saying it's always been a positive thing and opened up doors for me. Because how much stupid would that be, Kurt?
All the stupid.
All the stupid. He added, I might have one of the most famous penises in the music industry, but no one would ever know that to look at me. Sooner or later, I want to create a print of a real deal reenactment shot completely naked. Why not? I think it would be fun.
And he's done that. He did do a reenactment.
I know he's done a couple of clothed laying in the swimming pool. I don't know if he went on full on dingle shot, and I hope he didn't. And I
seem to remember that he did the swimming shot. I think they reenacted it. Unless I'm just imagining it.
I'll search for Farrah Fawcett, but I'm not searching for that one.
Okay, there you go.
The same year, Eldon confessed to Time magazine that he had been hard. This is where what Kurt said and what I said before Kurt showed up, it comes into play. That same year, Eldon confessed to Time magazine that he'd been harboring some resentment over the fact that everyone else involved in the album has tons and tons of money, while he was a grown man living in my mom's house and driving a Honda Civic. Wonder if Amber Heard's in the Honda Civic. There you go. You could take his Honda Civic and tie it into Amber Heard, and maybe you get some grift off of that. He admits his frustration about never receiving any sort of compensation for Nevermind had led him to look into pursuing legal action, but those efforts had been unsuccessful. It's hard not to get upset when you hear how much money was involved, he said at the time.
Yeah. So he likes money. And he knows that it's been incredibly successful, and he likes money, and he'd like some of that money. He has absolutely no cause of action at all, even a little bit.
And why not? Because the law is clear. Eldon has no claim for conduct he knew about before August 24th, 2011, and he knew about all of the conduct he has put at issue in this pleading.
Yeah.
The taking of the photograph, its inclusion on the Nevermind album cover, its worldwide circulation, the global fame, and his role in the photograph long before 2011. And in another snarky comment, it's not even close.
It's not even close. If it ever were to come to trial, we'll have to go find all the women you hit on and all the bars and be like, hey, do you remember the Nevermind kid coming up to you with the album? Like, yes, I remember. He knew. He well knew. Yeah.
Oh God. And then the defense lawyer continues to say that even if he does try to avoid the statute of limitations, in part as to post 2011 conduct, which is what, as I said earlier, he was trying to be tricky by mentioning that these horrific damages were still ongoing. Even if he tries to get around it by saying there's still post 2011 conduct, he has fucked up his pleading by not identifying what each of the 11 defendants supposedly did after August 2011. He didn't enter the pleadings properly. Anything. Yeah. Well, as they mentioned earlier on in the suit, some of them can't. Kurt Cobain was dead long before August 2011. It's kind of hard for him to do stuff after he's dead. In fact, Eldon's allegations fail to state a timely claim under the statute against any defendant based on any particular conduct. And as shown below, many of the defendants had nothing whatsoever to do with the conduct after 2011. Kurt Cobain, he was dead. He does not allege that Kurt Cobain did it. This is where they just go through every single defendant and show how they didn't do anything after 2011. This Kurt Cobain thing, I think, was just pure snark on behalf of the defense lawyer.
Yeah.
However, he does not allege that Cobain did anything in particular to violate the statute after the creation and release of the cover art in 1991. And it's inconceivable that Eldon could amend the complaint to allege such conduct when it is a matter of record that Cobain died on April 5th, 1994.
Yeah, I remember when it happened.
Why would the lawyers file a lawsuit like this? They know they can't win.
They're hoping to just a little throwaway money just to go away. Yeah,
I guess it could be looking for a settlement. Yeah, I guess that makes sense. This is where again they say you have to describe the.
If I am the judge, I'm putting an image of this thing right in my text of my decision. I'm putting a copy of the image right in there, like full screen style, right in the decision, just for that extra little bit of burn.
Just sue me, bro. Brandon Lesko was When I'm a Grower Not. You already read that one, but sorry about that. Flux, yeah. Hey, thanks, Flux. Couldn't he just sue for royalties for his likeness? Well, if perhaps his parents had been smart. But then again, they probably just would have gone on some other 4-month-old child whose parents didn't demand royalties. No, if he's not contractually entitled to royalties, he doesn't get royalties.
I mean, there was no particular expectation at the time that the album would be the juggernaut it was. So, they were going to pay you, a pittance for this, which is basically all it's worth, at least objectively at the time. The fact that it went on to be one of the most popular albums of all time, it was not necessarily foreseeable.
True. What's also not foreseeable is Brendan throwing me a major super chat. Thank you very much. Hey, Brendan, let's go. She was getting cocked down in Dallas, railed out in Raleigh, tag teamed up in Tennessee. She was very banal in Austin, better ducked in Boston, given neck in New Orleans. She was getting cocked. I have no idea where that's from, and I don't want to know, but
it's a song.
I don't know this song.
Well,
yeah.
Moving
Who
on.
sings this song?
I don't know who sings the song. I've only heard it once or twice, but yeah, it's
not. It wasn't on the Billboard charts. I'm imagining. Thank you, Brendan and Darrell. Thank you. Oh, thank you so much for the €5, Darrell. Thank you very much. Hello, gentlemen. Hello. She has the cutest little dog down there. I just love looking at this dog's face. Well, gee, again, this next part is just them saying he didn't say who did what specifically. So you have to be precise about your victimization. Mm-hmm. Even if he had reasonably pled post-11 conduct in a manner that could give a particular defendant notice of the post-2011 conduct that is alleged against him, Eldon has not, they say parenthetically, the claim would still fail. A victim of CP is entitled to sue within 10 years. And this is someone saying, well, maybe what if he was a minor in 2011? Here he wasn't, but here's the exceptions in case he was. A victim of CP is entitled to sue under this federal statute within 10 years of turning 18 or 10 years from when he or she first becomes aware that he or she was victimized by a defendant. However, a plaintiff is barred from commencing any action more than 10 years after turning 18 or after he or she reasonably discovers his or her victimization, the injury. So basically, you have your latest date would be 10 years from the time you turn 18.
Yes, since you knew about it before you were 18. You knew about it when you were 17, as we've proved. You knew about it when you were 14. And this is not CP, just to put a fine point on it, right?
Yeah.
This is all statute of limitations problems. Even if we could get past the statute of limitations problem, this is not CP. It's not even close to CP.
Ooh, and that's where this argument goes right here, where the claims just fail on its face. That just means it's not worth the paper it was printed on.
It is
essentially
definitely
what the lawyer's
no.
saying. As a companion to the CP claim, he's asserted the defendant's creation of the Nevermind album art cover involved the sex trafficking of youngsters.
No.
So any of you that bought that album, downloaded the song or whatever is complicit in child trafficking under this theory. And they're saying this new statute that was created in 2003 enables the victims of such trafficking to have a civil claim against their traffickers. And here they
if
just
this
proceed
were
to
CP, then then many parents would be guilty of CP, right? Just to put the definitions on it, right? It is not enough that you're taking a photograph of a minor in even an unclothed state. That's not enough for CP. It has to be taken with what the law actually uses, the phraseology, the prurient purpose. It has to be taken with this sexualized purpose, or it's not CP. So it is not CP to take a picture of a child as a parent, like if you're bathing them, as many parents did, which, although embarrassing, is not CP. This is not CP. This is just a child in a swimming pool. There's nothing particularly prurient about it. It's not exploitation. It's not trafficking. These words mean things. This is not even close to what the law is contemplating. This is dumb. And also, if it were CP, it would mean that everyone who had owned the album would be guilty of possession of CP, which also is another problem.
Yep, you would be felony child P.
Yeah, which is basically everybody. Yeah, basically, because the album again was one of the most well-selling albums of all time, so everyone would be guilty of possession of CP. It's not CP.
When as Kurt says, words mean things. What does trafficking of children mean? They go on here to say it means the recruitment, enticement, harboring, transportation, obtaining, advertising, patronizing, or solicitation of a minor in or affecting interstate commerce, knowing that the minor will be
forced to engage in commercial. There's your trick. Knowing the minor will be forced to engage. None of these things. None of these things. No.
Or you participate in a venture that recruits, entices, harbors, transport, in a venture that does this, while knowing the minor will be forced to engage. Either you do it or you're engaged in a venture that knows this. In other words, child sex trafficking is a type of human trafficking that involves persuading a minor to engage in a sex act. And Eldon's trafficking of children claim is fatally defective on the face of the complaint for at least two reasons. One, the trafficking predates the enactment, and the claim is time barred.
Also, it's not trafficking.
Which is the next part.
No one was forced to engage in anything. No one certainly knew that they would be, nor even was it contemplated in anyone's mind.
And that's dealt very effectively here with the Eldon presumably claims that defendants knew that Eldon and the other baby models would be forced to engage in a commercial act at the 1991 photo shoot, and thereby engaged in the trafficking of children. Ludicrous. It's just ludicrous. That's how you might
have wished that certain women would be enticed to engage in sex acts with you. That may or may not have come to pass, but to the degree it did or did not, is not what Congress had in mind. Also, even if Congress did have it in mind, the First Amendment would be a problem at this point.
And then they say, even if it wasn't ludicrous, it's still time barred. He waited too long. So therefore, we request that the court dismiss this action with prejudice. And again, that means they cannot bring this action again later and enter a judgment in favor of the defendants.
This lawsuit is dumb.
What do you think? Dumb. Do you think they should grant the motion to dismiss, Kurt?
Yes. Immediately. With mocking tones, using lyrics from Nirvana. That's what I would do as a judge. This is where I'm breaking
get one
out
of those creative poetry. Yeah,
this is where I'm breaking out the lyrics of albums and I'm using them in my decision because I can.
Yeah, just get one of those good lyric judges that write poetry and just get one of them to piece together lines from Nirvana lyrics. That'd be good. Wait, who's that said my dad on that album? You can just go right away with that my dad stuff.
My heart is broke, but I have some glue. Help me inhale and mend it with you. We'll float around, hang out on clouds. Then we'll come down, have a hangover.
You owe me a drink. Is this lawsuit subject to an anti-slap?
Mm.
Well, it wasn't. I know so little about anti-slap things that it's scary. That would be Kurt's comment. Any comment?
I don't know the degree of your knowledge, so I can't intelligently comment. But this is just a dumb. This is a dumb.
I know
that's my legal analysis. This is a dumb.
Well, I know that much. I looked up the anti-slap stuff when the Depp Heard thing was going on, and I still don't have any idea what it really means because it's just so far out of my bailiwick. I read it and then I instantly forget it because it will never touch my life. So that's just me. Well, what do y'all think? Did Kurt went full Gene Autry? Other elder statesmen in the line here. What do y'all think happened? They asked for it to be dismissed with prejudice so it could never be brought again. And I was kind of surprised at the court's response. The court was very, very, very nice to the plaintiff.
That's
Well, I mean, it's not very common to get the entire lawsuit dismissed with prejudice on your first motion to dismiss.
No, it's not. But this one, I feel like I can do it. This one, I'm there. You have no possible legal theory. There is no way to fix this. There's no amount of amendment that could possibly cure this. You're just done. You're done on every possible level.
I think the judge agreed with you, but they still had to at least give them the opportunity and give them the mission impossible if you choose to accept. This is what they were told. Well, no, okay, wrong. That happens later. This first one, they required the plaintiff to file his opposition to the motion. So they file the motion to dismiss, and then the judge says, you need to file your motion objecting or your motion opposing the dismissal.
I don't need a motion object. I'm doing everything sua sponte. I don't need to read anything more. I can just do it on the face of the complaint. I don't even need a motion to dismiss. I'm just going to do it sua sponte. I can. There's nothing stopping me. This is dumb on its face. I'm done, and this is done. Then there's no need for a response.
Well, that's apparently what they thought because they required the opposition to the motion to be filed by December 30th. The plaintiff did not file any opposition to the defendant's motion. But the policy is favoring amendment of complaints. So therefore, the court
not when there's no possible amendment that could possibly make this better. There's no way to do this. It's not possible.
But at least they give them the chance. The court will grant defendant's motion and give plaintiff one last opportunity to amend his complaint.
The judge is soft.
Because the motion was on the first amended complaint, so it's already been amended once. And this is his one last opportunity. In preparing the second amended complaint, plaintiff shall carefully evaluate the contents set forth in defendant's motion, including defendant's assertion that plaintiff's claims pursuant to are time barred. So basically, they're saying you got to come up with a reason why the claim should not be time barred. And time bars are time bars are time bars with very few exceptions for a reason. So it's ordered that the motion to dismiss the First Amendment complaint is granted.
With
The
leave
hearing
to
is
amend.
vacated. Yep.
The judge
First
is
Amendment
soft, man.
complaint.
I'm giving sanctions. I'm making him wear a sign outside the courthouse. I'm the Nirvana baby, and all I got was a stupid sign.
Exactly. That's exactly what I was going to say. Like literally exactly what I was going to say. The First Amendment complaint is dismissed with leave to amend, and this was filed on January 3rd. So they gave them like 10 days to refile their motion, their amended complaint. And the plaintiff is cautioned that failure to timely file shall result in the action being dismissed without prejudice for failure to prosecute without prejudice, and or failure to comply with the court order.
Man, well, I've prejudice for this.
Well, we don't have to worry because they filed their second amended complaint.
Oh, joy! Does the Second Amendment make everything better? And do I owe them a massive apology?
Stand by.
Okay.
Stand by for news, as Paul Harvey used to say. Blast through a lot of this, lots of court cases. Make sure I'm reading the right one here. Oh, never mind.
Do any of those cases say that we're not idiots?
No.
Okay.
So we don't look at the I didn't bring up the second amended complaint because it's pretty stupid. I mean, literally. Like the thing with the amended complaint, if you file a 50-page complaint and then you have to amend it, you don't just get to file the amended paragraphs. You have to refile the entire thing. Mm-hmm. And the second amended, you have to refile the entire thing without making note of where the amendments are. And they just basically say the first two things never happened. And so it wasn't worth going through it again. But again, there's the second motion to dismiss. And in the second motion to dismiss, you can piece together what little or nothing was done on the second amended complaint. So they filed the second amended complaint. Then the defendants came together and said, all right, let's file another motion to dismiss. Renovaggio says refile. Pretty much. That's about as good as you're going to get, is just at the court and hope something sticks. So yeah, they lay it all out here. Very well organized. Lots of cases, lots of statutes and rules. The second amended complaint is Spencer Eldon's third attempt to contrive, and like this is where they just go completely snark. They don't even try not to be snarky at this point. It's just full on humiliation of the plaintiff and his legal team. Their third attempt to contrive a claim for money by pretending that the 30-year-old photograph on the cover of the Nirvana album Nevermind, one of the most famous and widely possessed photographs in history, is CP. While there is no serious question that the photograph is not CP, Eldon's case is long barred by the statute of limitation. For Eldon, this is strike three. This case must end. Well, that's a calm, cool, and collected way of starting out your motion. And it just kind of goes downhill from here. The court granted defendants' motion to dismiss the first amended complaint on the limitation grounds. In its order, the court warned Eldon that he would have just one last opportunity to amend his complaint to cite a timely claim against defendants. In his ever-shrinking pleading, Eldon has now dismissed all but one of the myriad state and federal law claims he previously attempted to charge against defendants. The sole claim left is under this statute, which provides a civil remedy to victims of CP. And that statute has a 10-year statute of limitations. Eldon's Second Amendment complaint makes it clear that he has not and cannot meet that 10-year limitation period. 10-year limitation periods bar Eldon from suing after turning age 28, more than 10 years from the reasonable discovery of the violation, or more than 10 years from Eldon's reasonable discovery of the alleged injury. The reason why we have these periods, they're designed to provide victims of CP with ample but not unlimited time to sue for a similar remedy. There are repressed memories. As much as I really, 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 really hate that defense, there are There are things where you can say, okay, later I realized I was damaged. I realized this happened, but you can't do it when you're 800 years old and say, okay, yeah, you have time limits, and they gave you pretty ample limits. You're turning 28, that's pretty good. Well, Eldon turned 28 in 2019, 2 years before. Darn, he should have filed the lawsuit a couple of years earlier. Then he'd at least have a fighting chance. He can't, he'd at least be in the ring. It wouldn't be a fighting chance, would it? He cannot rely on this limitation period that runs from his 18th birthday. There's no dispute that he was aware of any supposed violation that occurred while he was a minor. Supposedly, the taking of the photograph itself and its worldwide dissemination during Eldon's minority for more than 10 years before the filing in 2021. Indeed, Eldon, long before 2011, celebrated and found his own ways to monetize his fame as the Nirvana baby. Thus, 10 years, I like this hyphenated phrase, the 10 years from discovery of violation that occurred as a minor provision does not save his claim. There's no dispute that the injury was more than 10 years before filing in 2021. And here's this thing, which is very prophetic. And I wish they hadn't put this in there, because I think this may have given the plaintiff an idea. Eldon likely will try to escape the time bar by asserting that defendants, or perhaps some of them, again, the pleading is not clear, have continued to do what they had been doing all along. So that's at least setting up the argument, the possibility that Eldon is going to argue. But even after 2011, they're still trafficking me. They're still exchanging and selling CP out there. It seems like you don't buy that, Kurt.
I do not.
Why would you not buy that seemingly logical argument that they're continuing
to
traffic?
Very many reasons, so many quotes, and so many instances with him being well aware and lauding it and promoting it and encouraging it and all those things.
Guess what? I've forgotten to bring up the screen here, so we're just doing audiobooks by Jeff.
Oh,
hello everybody.
Oh, if you want to do audiobooks, I could do a segment of a chapter from Chad Daybell, which I've been reading on my stream from time to time, from the Chad Daybell, Lori Vallow cult murder case that's happening in January. You know that one in Idaho?
Yeah.
So I have been on my channel. I have been reading segments from one of Chad Daybell's many books, and I could read some of his segments if you like.
Zero Max. Thanks. Damn it, you boomer. We can't see anything. And as those of you that were here last night and watched me do that last night, this is why I'm damned if I do, I'm damned if I don't, Kurt. If we do it like this, I get people saying, bring up your faces, make it bigger, hide the thing, we can wait. And then I'm looking at the other screen, not the StreamYard screen. And then I get so involved that I forget to make sure it's back up. So this is why I don't do it. People yell at me if I do it, and I don't. So again, yesterday's rules are back into effect. Even if I stop this and talk for 5 hours, I'm not removing the integral document from the screen, because I will not bring it back up, because I'm an idiot. Daybell. So that's I told you I'll be your resident Mormon expert on that anytime you need.
Excellent.
Any doctrinal issues, just let me know. That's going to be a shit show and a half. Well, like I told you several months ago, and I'm just going to wait until the trial and deal with the trial issues as it comes up, because I don't think
that's an unreasonable way of dealing with it, to be quite honest. The case is so complex with so many people and moving parts.
Forget so many people and moving parts. It's so many dead bodies. It's
there's
not
that
just
too.
Kids.
There's that too. I think there's a decent possibility that the prosecutor screws it up, gets everyone lost. Because this case is so complex. I mean, keep it simple, stupid could work as a strategy, but if the prosecution gets lost, who knows? We'll see.
I don't think I'm particularly stupid, but like I told you several months ago, I tried to make a timeline of who did what when, and I had to give up because there was just no room for lines and diagrams, and so-and-so's ex-husband is dead. Someone's wife was the cousin of someone murdered who disappeared. There are lots and lots of dead bodies in this. A surprising number of dead bodies.
Number of dead bodies, yeah.
And it's in a very, very tight family tree.
That's one way to put it.
Well, I bring flashback to church decades ago. We had one guy in the car. We were talking about genealogy that day and creating like a family tree. And he was a serious like backwoods Kentucky Appalachian hillbilly guy. Well, I got to be honest with you. My family tree has a few intertwined branches. And we see that in the Daybell case a little bit.
Yeah.
But yeah, that's going to be fun.
Oh yeah, no, I'm looking forward to covering it on my channel in January. It's going to be one hell of a trial to follow. And I'm looking forward to doing day-to-day coverage as we try to figure out what the hell happened.
Seriously. But I think you're right. You've just got to stick with kids were alive.
Kids are dead.
Kids disappeared. Parents went on vacation. Didn't help. The end.
Yeah.
Children found
in backyard.
Yeah. The end. That's I think that's the winning argument. But let's see if how's that for a segue? Let's see if Eldon has a winning argument. The Eldon, he makes it plea.
Daybell has better chances than Eldon does.
You're absolutely correct. Unfortunately. Okay, so yeah, again, Eldon's pleading makes it clear that he had discovered well before 2011 that defendants had created the photograph, included it in the Nevermind album cover, released the album cover to the public, and made it available for general public consumption every single minute of every single day since 1991 for 30 consecutive years. Well, it doesn't matter because the same defendants are doing the same thing that they did before 2011, so you can't claim that. But his problems do not end here. Aside from the problems caused by his decades-long knowledge, you don't want to have someone admit you have decades-long knowledge before you file a lawsuit.
No.
The decades-long knowledge of his alleged, I'll say it for him, victimization by defendants, Eldon still has not met his pleading burden to identify the particular conduct committed by each of the 10 defendants. Again, even if this is happening, even if it's not time barred, he didn't say who is doing what to me. It's just everybody is doing everything. He continues to evade the basic pleading requirement because he and his counsel, now you're bringing counsel into it. This is unusual.
That's mean. Don't bring counsel into this.
Yeah, we just usually we suspend disbelief and we accept the fiction that the plaintiff himself is writing these motions. It's really uncommon to bring the counsel into the arguments, at least as far as I have experienced.
Yeah.
Because he and his counsel know that particularizing the allegations against each defendant would reveal that most of the named defendants engaged in no specific conduct in the past 10 years to merit involvement in this action. Scroll through the same arguments we've made before. To survive, and this is the interesting thing that anything you want to say, Kurt, jump in and say, now it's not, is he meeting the requirements to have the motion to dismissed, the motion to dismissed, I guess that makes sense. But now it's already been dismissed once. So now we're to this point where to survive a motion to dismiss, it's been dismissed. Now they have to refile their claims and try to overcome this motion to dismiss. The complaint must contain sufficient factual matter accepted as true to state a claim of relief that is plausible on its face. In essence, and maybe oversimplifying it, just mean if you're going to refile, if you're going to amend your complaint to avoid a motion to dismiss, it has to pass the bullshit test.
Yeah.
It doesn't have to be logical. It doesn't have to be well supported. It just has to be plausible. You have to, it just can't be complete and utter bullshit. Get a step above bullshit, and I think we'll hear you out.
This is not a step above bullshit.
No. So applying these standard cases are often dismissed because they're time barred on the face of the pleading. Again, you got to overcome this time bar thing, and that's their argument. We don't even need to go into the details. It should be dismissed because despite all of this stuff they've put it in their second amended complaint, they still haven't overcome the time bar issue. And so therefore, this failure, it should be dismissed. And then again, this is kind of funny. I like this. This is again saying you didn't say who did what, when, and how. Eldon's pleading is defective for another reason. The other reason was it's just time barred. You didn't address why he can still bring claims. Eldon's pleading is defective for another reason. As before, Eldon's pleading still does not separately identify what any particular defendant did after 2011 to give rise to his or her respective liability. Instead, Eldon's pleading generically alleges that all 10 defendants, we started out with like dozens, now we're down to 10 defendants, that all 10 defendants as a collective unit committed every criminal offense under the sun, from possession, transportation, reproduction, advertising, promotion, presentation, distribution, provision, and or the obtainment of alleged CP. Eldon's position that all 10 defendants, ranging from the individual defendant who took the photograph, record labels that no longer exist, so yes, even record labels that no longer exist are still doing things bad to him, and the estate of the lead singer who died in 1994 must have all committed all of the violations of the criminal statute together and in an identical manner from 2011 to the present day is implausible on its face.
Stupid.
It's well settled. It's
just
well
stupid,
settled.
Dumb, and an insult to this court's intelligence.
Yeah, that's and then they just kind of end it there going, he's an idiot. Now, again, please dismiss this action with prejudice so that they can never, ever, ever, ever bring this amount of stupid into the courtroom again.
The stupid hurts. The stupid hurts, and the court should not be allowed to be used for the stupid. That is not what the courts are for.
Porcelain Thunder, no countersuits. Nah.
I went through a lot of education so that I didn't have to deal with the stupid.
Yeah.
I take an offense at this.
And that's why there's no countersuits. He's already admitted he lives in his mom's basement and doesn't have any money. There's no reason to go after him for anything. It would just be a waste of time and money. But we'll give them credit. This time, they did file an opposition to the defendant's motion to dismiss.
Whoa.
So now we're going to look at what the plaintiff did, what Eldon did to try to overcome that motion to dismiss.
Oh, this will be good.
Why he thinks this motion to dismiss is
Sell
incorrect.
Sell me.
Ooh, we'll try. We'll try. But quickly here, Flux, I wish I had a cowboy. Flux, you have a lot of cowboy. You have a lot of hats. Just get one.
Yeah, you can get
This hat is from Miller Hats. All of my cowboy hats are from Miller Hats in Texas.
And this hat
Miller
is
Hats
custom made by hand by Texas Hatters in Lockhart.
Sweet. Texas Hatters. Have to look them up. Yeah, this is Miller Hat. They do some customs, but they do a lot of. I like it because I have an enormous head.
Oh yeah, that's my problem too. This is 8 3/8.
Dude. Never mind. I just have a measly 7 5/8 head. Holy God. Yep. Okay. Miller
yeah,
hats
no, that's
you.
one of the reasons it's custom. I literally can't go to the store and buy hats. My head is too big.
Yep.
Yeah. You have a big head. Okay, well, I'm an 83. Okay, never mind. That's a good moment there. And
wow,
friendship.
I guess my 7 5/8 isn't as big as I thought it was. You said 8 3/8?
Yes.
That's impressive.
Thank you.
Cool. Wow. Moving right along. Texas Hatters, you say?
Yes.
I'm always up for getting new hats. Let me just put this in here so I don't forget it.
They were the official state hatters at one point for Texas. They made the hats for the legislature and stuff, so they've got quite the reputation. So I recommend them. Obviously, they made this beautiful hat, 100% beaver fur.
Cool.
As you can see here, nice little lining here.
Nice.
In the style of Gus, made in Texas, United States.
You have no idea how happy I am to meet someone who has a bigger head than me. This is like a first.
Glad I could help.
Thank you. Wow. Yeah. For those of you that this is like the largest hat that Miller Hat sells. And I like them because my head is round, but it's also like oval. So they can do like a long oval bend. Because otherwise, if I just buy like a normal hat, I have these huge spaces on the side, but they like bring the long oval thing. So,
yeah.
Rare in history says, Beaver, you say, on your head, eh? Well, my black cowboy hat is that's Beaver as well. So yes, there's no place better for Beaver to be than on your head.
Mm-hmm.
Back to the super chats. Cough, cough, cough. Flux, get a cowboy hat. You deserve one. You should have one. I thought you already had one. Brendan, Eldon doesn't have any money. Doesn't have a money shot, sadly.
Oh, that's a nice one. Good joke.
Yeah. Next. Flux again. Thank you. I followed this case so close when the kids went. Oh, this case, your case, the Daybell case, when the kids went missing. It's so bizarre. How did the grandparents not do anything? Comments, Kurt. How did the Daybell grandparents not do anything?
I don't know what's going on with that family. It's a special family.
As many people in Idaho are.
Mm.
And just watch. People in Idaho will say, yup. None of them will go, how dare you say that about Idaho? It's just a fact. People in Idaho and northern Utah are touched. It's like when Napoleon Dynamite came out. I remember there was an article in the New York Times about how horribly offensive this movie is, that you're making fun of country people and things. And I was watching it. You've seen it, right? Napoleon
It's
Dynamite.
been a long time.
Yeah. Well, there's a scene in there like where they're in the 4-H club and they're working at the chicken farm. If that camera had panned about a quarter to a half inch to the left, my aunt's house would have been in there. Nice. So when they're doing all this Napoleon Dynamite, and the New York Times is complaining about it being upsetting to people in Idaho and country folk, I'm thinking, I literally know everybody in this movie. Exactly. These people live in my neighborhood. This is like Tuesday for me.
Nice.
People in Idaho are different.
Yeah.
We have
Aaron Paul is from Idaho.
Yes, he is. Legal Vices, read my last message. Was that what was your last message, Alan? You can't just do that. Just repeat it. Your last message is Legal Vices. All right. I assume you meant your second to last one. You're interrupting the flow, Al. Where are you at here? Aha. Legal Vices. Please read Kitty Cat's last. This is like a choose your own adventure book you've got going here, Alan. She's been asking now for a while. So you could have just put the question right there. Now let's go search back for. Now it's a quest. Now it's a mission.
Yes, the quest to find the thing. And sometimes that could be a challenge.
Okay. I'll ask one more time. Would the little girl from the Coppertone commercial have a lawsuit? No. Nor would the Gerber baby. But to quote Clint Eastwood, what about the rights of that little girl? She didn't have any. She didn't sign a contract. I'm pretty sure the Gerber one did, but yeah. Nope.
The Gerber baby was extolling that well up into her 90s when she died. So
yeah, which was just recently.
Yeah,
if I recall.
It wasn't that long ago. Yeah.
This COVID thing has totally warped my sense of time. I have no concept of time anymore. Yeah, remember like when last year we were doing? They're like, dude, that was 4 years ago. Oh, sorry. Yeah. Well, now that we're here, working our way towards the end of this lawsuit, I'm just noticing that we have currently only 419 people here, but the likes are in the 305, so 100 of you at least, and I know not all of you are here when it started. Everybody just go down here and like, and while you're here, go to Kurt, and I assume everyone that's subscribed to me is subscribed to Kurt, because I'm like the new idiot on the block here. So if you haven't for some reason subscribed to Kurt, go over to Uncivil Law and subscribe to Kurt. Like the two of you that aren't already subscribed to him, but make sure you two get your ass over there and do it immediately. Like, can I say ass yet? Or not at the 2-hour mark yet?
Fine.
I'll get vulgar in 5 minutes and 45 seconds.
I think the 2-hour mark wasn't it after 2 hours, not 3?
Yeah, we're at 154. 15 seconds right now. But yeah, so go over to Kurt, hit like and subscribe on his all of his. Well, subscribe once and then hit all like on all of his videos. Like my videos because you've been here. Come on, it takes like 1 second. And subscribe if you haven't already done so. And for both of us, YouTube is now on this purge of subscribers. If you are subscribed to either of us, make sure you're still subscribed because they're just kind of purging subscribers, it seems, at the moment.
Yeah.
And that's it. Now, I guess as long as Kurt's here, you can use the you can use my cowboy emoji for both of us because it's fluid at the moment, I guess, for lack of a better word. Well, now let's jump back in here and see what these geniuses over at the plaintiff's factory for Spencer Eldon, what kind of wizardry they're going to try to use to overcome this time bar and
the fact it's not CP
issue.
And the fact that he knew about it and the fact that he's just a greedy person who never made anything of himself and really would like some money. He's still chasing that dollar just as he ever was.
I resemble that remark. That sounds a lot like me. Well, here we go.
You've done something valuable with your life and people like you.
Yeah, I get paid to make fun of people like this guy. But we're down to 10 defendants: Nirvana LLC, Universal Music Group, UMG Recording, the David Geffen Company, Geffen Records, MCA Records, Kirk Weddle, who was the photographer, Courtney Love is executor of the state of Kurt Cobain, and Chris and David Grohl. There we go.
Don't bring Courtney Love into this. She's going to kill you.
Allegedly. Have to say that. All right. So here, Spencer Eldon, through his attorney, Robert Y. Lewis of the Marsh Law Firm PLLC, not even an LLC, a PLLC, hereby submits this memorandum of law in opposition to defendants' motion to dismiss the second amended complaint. So this is their Hail Mary. This is it. They've got this entire lawsuit riding on these arguments. And here's some of this stuff here. Sometime in 1990, defendant DCG Records hired Robert Fisher to serve as art director. And this is where we get into the prurient interest shit. So I guess if you need a trigger warning, you kind of learn that
prurient.
Yeah,
I was in trouble pronouncing it properly. Prurient.
Yeah,
whatever.
It doesn't matter. Dirty stuff. This is where we get into the dirty stuff. And this is where I learned a little more about Kurt Cobain than I ever really wanted to know. But yeah, according to Fisher, who is the art director, Nirvana wanted images of nude babies for the cover of their 1991 Nevermind album.
I mean, that seems readily apparent, obviously.
Yeah.
So yes,
surprise.
Tell me something I don't already know. That'd be great.
Cobain, Fisher, and defendants Novoselic and Grohl determined that they had to, quote, make the photo more than just a baby underwater. They engaged in an extensive debate about what to pair with the naked baby on the Nevermind album cover, considering a dollar bill, raw meat, a dog, and other objects commonly associated with prurient interests. Raw meat is associated with prurient interests?
I'd object that any of those things in particular are associated with prurient interests.
A dog? I don't know what websites
I don't want to know what websites.
Yeah. Nirvana ultimately decided prurient again just means dirty.
Well, usually
appealing to your basic,
sexual. Usually
appealing to your base sexual desires.
It's a great word. It's a word I use all the time because I don't want to use like the R word. So I'll say forcible prurient interaction and stuff like that instead to try to get around the YouTube censors.
Well, they ultimately decided to use a dollar bill on a fish hook as a prop with a naked baby. Why? Why a dollar bill on a fish hook with a naked baby, you ask? Because you're all filthy people and they're trying to get your filth to get their this is the worst. This just makes him seem way worse than anything he's accusing Nirvana of doing. All right, I don't even want to read this. This was a journal entry from Cobain that was really talking about just horrible shit. I like to make an incision in the belly of infants and fuck their incision until the child dies. I haven't masturbated in months because I've lost. I mean, this is like a really horrible thing that is really, really horrific to the point where I don't want to read it. Damn it! I should have waited another minute to read that.
What was he writing about?
It was just it was a diary entry. I think it was like a stream of consciousness thing where.
Okay.
Yeah, it was pretty horrific. Go read the complaint if you want, but yeah, it's not good. Weddle took a series of photos of Spencer, who was then a 4-month-old infant, in a pool at the Pasadena Aquatic Center in California to ensure the album cover would trigger a visceral sexual response. Weddle directed that Spencer's gag reflex be activated before throwing him underwater, after which he took photos that highlighted and emphasized Spencer's exposed genitals.
No.
I hope none of you got that out of that picture, because I certainly didn't.
What the hell did I just read?
Where? Which
no,
part?
I mean,
that
just
part?
the thing you just literally recited.
Okay.
I was still processing all that time.
Yeah. Yeah. Well, it gets worse. It gets worse. The image of Spencer with his naked genitals displayed while grabbing at money resembles the action of a sex worker. By show of hands, how many of you in the chat looked at that album cover and said, "Oh my God, that's just like a sex worker"?
No.
If any of you thought that, get the fuck out of my chat immediately. I do not want you here.
Can I suggest some nice walls that you might like?
No, Weddle is a photographer. You know, cherubs. I mean, that's a cherub picture that's been around since Roman times. There's statues of cherubs and things like that. You know, or maybe it was even around before Roman time. We don't have things that old. But no, he was just a photographer. This is what the plaintiff is alleging was in Nirvana and the photographer's mind when they were taking this picture. Yeah, the
even if somehow all that was subjectively in their mind, which is one hell of a thing. The photo itself doesn't do any of those things. So the photo itself doesn't, even if somehow that was. It doesn't. Okay, I'm just going to run into a loop of logic if I keep thinking.
Yeah. Okay, data, just stand back. But no, and this is one thing. This is what the defense were saying. No, the image was just supposed to show how we're grabbing for the money, we're struggling, we're doing the grift from the time we're born. Not, you know, all of this shit that this freak is pulling up.
Mm-hmm.
I mean, the things that he says in his lawsuit, and especially in this motion, I guess not a motion. What is it? It's the objection to the second motion to dismiss. The things that he says in here tell me more about him and his lawyers than it does about Nirvana.
Yeah.
This is the shit they're willing to throw at the court and try to get people and hopefully a jury to believe. That, I mean, who would look at this picture and think, oh, that resembles the actions of a sex worker? Ugh.
I feel uncomfortable.
Yeah, when the album cover was nearly complete, Fisher routed a final mock-up to Nirvana and Geffen Records, attaching the note, "If anyone has a problem with his dick, we can remove it." So they're just saying, if anybody has a problem, we can get rid of it. And nobody had a problem with it. So at some point in time, Cobain was confronted about the Nevermind album's cover appeal to pedophiles. So he was asked about it. He was asked about it to pedos. In response, Cobain sardonically declared that they should put a sticker on the album cover stating, "If you were offended by this, you must be a closet pedo." I absolutely agree with that. And this is making the case for the defense.
Yep.
They're trying to show this. They're trying to do this to show that Cobain was some sort of pedo that wanted to exploit this child sexually. And they're quoting him as saying, "If you're offended by this, you're a closet pedo." This is like Alec Baldwin's prop master. What was her name? Sarah, whatever the fuck she is, doing an accidental discharge into her own foot 2 days before Alec Baldwin murdered the chick. This is your chance to say why you're right. And this totally, in my view, totally supports that the Nirvana side was concerned about this, and they decided that it was art and it was going to go forward, not that it was some dirty, filthy thing. But nope.
Yeah.
That's the argument they used. Weddle, again, the photographer, and each of the defendants continues to be involved. This is how they have to. This is their Hail Mary at going after the 2000, the 2011 time bar thing. They have to show it's ongoing to this day.
Right.
So Weddle and each of the defendants continues to be involved. Again, each of the defendants, including the dead one.
That's a neat trick.
And the ones that don't exist anymore.
That's also continues.
A neat trick. Exactly. They continue to be involved in the sale, promotion, and distribution of the album and other logoed products using Spencer's image as part of the recent 30th anniversary re-release. It's not an ongoing release. It's a re-release. So it's a new thing in their mind, as well as prior anniversaries within the past 10 years. Yeah. The title of the album is positioned so that the final A in Nirvana is pointing directly at Spencer's penis. You know when I noticed that? I noticed that last week when I read this for the very first time. I had never noticed that in 30 years.
I'm sure someone contemplated the alignment of the text on the image. So sure, why not?
Yeah.
If it wasn't the A, it would have been the I. I mean,
yeah.
Or it would have been juxtaposed between two letters.
Yeah.
I mean, whatever.
Exactly. You're exactly right. Spencer is depicted in a manner resembling a sex worker hustling for money.
No.
Spencer is
what sex worker? What are you talking about?
He's depicted in an unnatural pose at just 4 months. Well, I guess it was pretty natural. They just threw him into a fucking swimming pool.
Yeah, I mean,
and took a picture. I guess it was natural.
Yeah.
Wherein he was gagged and dunked underwater while unable to swim and while not wearing a swimsuit. Who brought up this gagging and dunking thing? Come on, people. The plaintiff is the one I'm worried about of all of these people. He's the one that doesn't get to babysit my kids. I had kids. Although the production of the Nevermind album occurred over 30 years ago, many other violations have occurred since then and continue to the present day. And then they go on to say that it's not time barred for some reason that literally made no sense and isn't worth getting into. Now here we go. They're saying that now equals then. If a defendant downloads CP that was originally created 30 years before the download occurred, the child depicted, who is no longer a minor, may bring a claim under Section 2255. While that's true, there's the three things like 28 years old, 10 years from the time it came out. They conveniently leave that out. Somehow they say that they properly pleaded and specified exactly what each one of the plaintiffs was doing, which clearly they didn't, so I don't even look at that. And then they end their motion. That was not the strongest motion I've ever seen.
No, I mean, I understand it's your duty to completely drain you, but this is pretty dumb.
Well, finally, we're to the judgment. Prototypo says a lawyer had to argue that with a straight face. He probably didn't have a straight face. He was probably
is the order that's the statute of limitations is something in the way? Is that what the order is?
Yep, this is the judgment.
Okay. Right.
The judgment of the court, the Central District of California. Spencer Eldon plaintiff versus Nirvana LLC and the other 9 peeps. The oral argument is not necessary to resolve this motion because they can either take the motion and they can hold hearings on the motion itself, or they can just rule on the submissions. We pretty much got this covered. We can just sort of look at the submissions and make our decision based on that. And we conclude as follows. He was basic facts. And for some reason, my highlighter wouldn't highlight a lot of these comments, so it's weird. But although the court granted defendants' initial motion to dismiss, the court dismissed the first amended complaint with leave to amend, and they amended it. Okay, so good job there. They did what they were told to do. And in their amended complaint, they say the defendants have engaged in ongoing violations of multiple provisions and has been sustained during the 10 years preceding this action. So they're saying it's not time barred because they've been doing this stuff ongoing up to the current present day. And the injuries he had sustained since then, and as a result of the defendant's past and commercial young person exploitation is ongoing. Well, the legal standard is a motion to dismiss for failure to state a claim should be granted if the plaintiff fails to proffer enough facts to state a claim to relief that is plausible. We go back to the plausible. Does it meet the bullshit test? Well, in considering whether to dismiss a complaint, the court must accept the allegations of the complaint as true. So again, the court starts from the position that, okay, the allegations are true. Let's just assume for the sake of argument that everything this crazy plaintiff has said is true.
Okay, I'll try to pretend for a moment.
Yeah.
Fine.
And when we make the pleadings, when we make these motions, we have to construe it in a light most favorable to the pleading party and resolve all doubts in the pleader's favor. So any concession they make, any consideration the court makes, they have to think of the plaintiff. That if they have to resolve them in the plaintiff's favor based on their decision has to be like what is best for the. What if what he's saying is correct? I guess that's the way I want to say. Is that the way I want to say it, Kurt?
Yep. Excuse me. Apologize.
They just want to. When you have to construe something in favor of the plaintiff, is any dispute, you have to think, what if the plaintiff is right in this case? Well, they tried to do that. Dismissal for failure to state a claim can be warranted based on a lack of cognizable legal theory, which we call, it's a term of art we use in the law profession called talking out your ass. A lack of cognizable legal theory or the absence of factual support. Either you're talking out your ass or you can't support it by fact. A complaint may also be dismissed for failure to state a claim if it discloses some fact or a complete defense that will necessarily defeat the claim. Well, here's the discussion. The statute of limitations should be dismissed as untimely. That's the discussion. You didn't do it in time. That's all we need to look at. You didn't do it in time. You had your 10 years, you had your 4 years, you didn't do it. The plaintiff does not dispute, and these are the things that should have been in the plaintiff's motion. The plaintiff should have countered these, but of course they couldn't, so what are you going to do? Plaintiff does not dispute that he knew of the alleged violations committed by defendants while he was a minor more than 10 years before he filed the action. However, plaintiffs whose opposition largely ignores defendants' textual arguments. So basically, the opposition to the motion to dismiss, you just ignored everything that the defendant argued. He largely ignores defendants' textual arguments regarding the statute of limitations. It contends that the violation which triggers the statute of limitations can occur anytime during the plaintiff's majority, during the time the plaintiff's an adult. Well, that's not the case. While a minor was a victim of a predicate violation, and thus violations occurred while the plaintiff was no longer a minor, including those that are allegedly ongoing or continuing, cannot form the basis. In short, because it is undisputed that plaintiff did not file his complaint within 10 years after he discovered a violation, his claim goes out the window. It's untimely if measured from his discovery of the relevant injury. Plaintiff offers no alternative definition for injury. You didn't do it in time. You didn't suffer any injury. You benefited from it. So the conclusion is, in sum, plaintiff fails to allege that he knew of a violation that occurred while he was a minor or an injury that forms the basis of a claim within 10 years of filing this action. Because plaintiff had an opportunity to address the deficiencies in his complaint regarding the statute of limitations and parenthetically failed to do so miserably, the court is persuaded that it would be futile.
Yep.
I mean, that's a strong statement, to be completely and utterly futile. Be totally futile to afford plaintiff a fourth opportunity to amend.
It was futile the first time.
Yeah.
It was so dumb.
But you've got to go through the motion, so there's no grounds for appeal. And Now they said, okay, you had 3 strikes. We don't give you 4 strikes. There would be no choice. You had 3 chances to get it right. You didn't / and or couldn't. So therefore, when the district court has already granted a plaintiff leave to amend its discretion in deciding a subsequent motion, its discretion in deciding subsequent motions, blah, 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 blah. Accordingly, plaintiff's action will be dismissed without the leave to amend.
Thank God.
Therefore, it is ordered that the above captioned action is dismissed with prejudice. Judgment shall be entered accordingly. So as of September 2nd of this year, this lawsuit against Nirvana and the other 9 people is done, gone forever and ever and ever. They can never, ever, ever bring the same claim ever again. Yeah.
Appeal.
And I think money would better be spent not doing that.
Yeah.
John D says, mind Schabusiness.
Nice.
Yeah. That's how we started out the Schabusiness thing. She's changing her plea from not guilty to not guilty by reason of insanity.
Well, could be.
Could be, but I'm thinking no, because you to have the by reason of insanity thing kick in, you have to prove that you did not know it was wrong at the time you were doing it. The fact she tried to hide the body, not very well, but tried to hide the body while being completely strung out on a toxic cocktail of drugs that were never meant to be mixed. Yeah, she still knows she ought to hide the body. Kind of tells me she wasn't legally insane.
Yeah.
But what do I know? I'm not an evaluator. Porcelain Thunder says, legal advice, be careful not to get ricated, talking about pieces of paper with ink impressions of geographical features belonging to vertical building structures.
Mm-hmm.
Yeah.
Yeah.
Or, yeah. He'll be back. Flux again. This is just uncomfortable. They're making it sexual and it's not. It's a baby. This is gross. Well, that's what I mean. That's why this kind of motion, this kind of lawsuit tells me more about this guy than anything that's being alleged against the defendants. That they had to sit around and strategize that just ludicrous and disgusting line of reasoning.
Yeah.
Ugh. Amanda Harris says that's not a toxic mix of drugs. Well, any drug by its nature is toxic. Alcohol is toxic, but when you're mixing marijuana, meth, and trazepam, that ain't good for you. I mean, considering how they literally do all like a triangle of opposites of things, that can't be good for the system. And I would recommend you not doing it. It must have been embarrassing for the guy. Which guy? The lawyer? Probably. I would be embarrassed if I was a lawyer and I had to go, all right, we're getting paid. Let's do this.
I'm definitely getting money up front for this one. Anyone who took this on contingency is just as big as it is the client.
Would you have even, yeah, I mean, sure, there's no way you would want to take this on contingency. There's no way. But would you have even taken this case, or would you have said, save your money?
I said, save your money.
Yeah, I don't know why someone would do this. But I mean, there's always some lawyer that'll take some case and do just enough to keep himself from being sanctioned by the bar for filing frivolous claims. But it's over and it's done with. Nirvana seems to be safe from this guy until he tries to find new grounds for claims at some point in the future. And for me, I think I always think that if people spent half of the amount of effort they did into claims like this into doing something productive, he probably wouldn't still be living in his parents' basement and saying, "Hey, you want to see my penis again?" to girls in the bars. Give us some words of wisdom, Kurt. I'm at an absolute loss on this case.
I got nothing intelligent to say because this guy has nothing intelligent to say. Just, try to do something productive and meaningful with your life. And the 15 minutes of fame from the Nirvana baby thing apparently long since ran out. And I appreciate that you want to extend that, but it seems like that's over now. So you might want to try to do something else with your time.
Now he's the creepy 30-something-year-old guy in the bar going, "Hey, you see my picture? This is me." And people, who's Nirvana, dude? That was just distasteful to talk about for an hour and 20 minutes.
Yeah.
I'm literally at a loss. The guy is sad. He needs help. This guy needs help. If anybody needs help. I mean, I think, I don't know who, I'm not a sociologist, but it seems to me as it's the kind of guy that when you're 17, 18, 19, 20, you think you can ride that particular grift forever. So you literally do nothing with your life, just thinking you can ride this out. You'll still be able to be the Nirvana kid when you're 80. You'll still be able to rake in the bucks and sell stuff on eBay. That's just the kind of the vibe I get from this, just sadness.
Yeah, definitely, for sure.
Brandon, let's go. The contents of this stream is disgusting. Brought to you by the American judicial system.
It should have been dismissed a lot earlier. It's my only real strong criticism of the court. I mean, there's no reason to allow this to be amended. The court should have denied it after the First Amendment amended. It shouldn't have allowed the First Amendment. It should have denied it out the gate because it's just so dumb.
But I mean, don't you think it was a prudent thing to do to allow them to exhaust their legal remedies before you dismissed it, so that you can just be seen as a prejudicial judge that was, that had it out from day one and didn't allow them to their full rights under the law to be heard?
I heard as much as I needed to adjudicate the case. I heard all the things. I heard everything I needed. I was done.
Don't be I'm sure the judge thought that too, but do you agree with the CYA part of it? Just the old cover your ass, let him try to do it again. We know it's not going to happen. I've given them impossible instructions.
If I'm a federal district judge, CYA from who? The Court of Appeals? I mean, come on. I know. Well, who am I CYA?
It is the Ninth Circuit. It is the Ninth Circus. So you have to take that into account, that it is the Ninth Circuit you're dealing with, and they could come up with anything they damn well want.
I guess.
You don't buy that argument, do you?
I feel like I knew enough to adjudicate this long ago.
There's no doubt the judge knew that. To me, it was just like, okay, I have to give them this opportunity. We have to err on the side of allowing amended complaints, amend this to show why the time bar doesn't come, knowing that it can't come and knowing how it's going to come, but just letting them go through the motions to remove one more item for appeal. That's kind of how I see it, but I could be.
I don't know. When I feel like
that's what I said. I said the Ninth Circus for a reason.
I just want to get to the answer. When I feel like I know what the answer is, I just want to get to the answer. It's like, oh, I can solve this by just doing this problem. Or it's just like, if I can find a short circuit, and I don't think I'm alone, at least in thinking like this. And I think there's a lot of judges who think like this. Like, if I can find like the easy path that gets me to where I need to be and adjudicate this thing, then great. It's like, find water, let's water on pavement, finds every crack and crevice, finds the path of least resistance.
Yeah.
It's like, this is easy, right? For every possible reason. The statute of limitations is long since gone. This wasn't CP. It never was. You knew about this. You were extolling it and virtuing about it. I mean, there's nothing about this makes any sense. So why do I need to hear anything more?
Well, Digger 420 asks, legal advice, could you please explain the difference between circuits? Just the federal courts, the entire United States is divided up into different circuits. It's just the area they cover. And the Ninth Circuit is just genuinely certifiably crazy because they're all a bunch of liberals from the West Coast that they're just insane. Kurt may have a different opinion. I don't know. But coming from Utah over in the 10th, we just that's why we call them the Ninth Circus Court of Appeals, because they're just kind of insane.
Yeah, they definitely have had their moments. Although they're not the exclusive whipping boy that they definitely were at one point, where it's just like they were the least favorite child. Now it's the Sixth Circuit on habeas. The Supreme Court loves to whack them around, and the Court of Appeals for the Federal Circuit, because they like to think that they're the Supreme Court, and the Supreme Court has, at least in recent memory, reminded them that they're not.
The Supreme Court likes to think they're the Supreme Court.
Mm.
Joe Choi, thank you so much. Can we keep voting for Rackets on the Grifties, guys? Yeah, go ahead and get Rackets as Grifties. Is I don't know where is he number 1 or is he number 2 at this point? Whichever he is, just keep voting. If he's at number 2, get him back up to number 1. If he's at number 1, keep him there. We need our Nick back. So anything we can do to get our Nick back. We need the Pope Father.
Stop these injustices that are occurring. And remember to check him out on Rumble in the meantime, where he's continuing to do his streams. So, and maybe we'll all wind up there sooner rather than later at this pace.
I hope not. It's just a shitty interface. It's just horrible. But hey, if that's where it's going, I don't know. I love YouTube, by the way. YouTube, you're awesome. You're great. You're special and wonderful. And I would never, ever, ever, ever have anything negative to say about you. Mm-hmm. But just had to get that out of the way.
I appreciate that.
Yeah, I just can't imagine that they don't care about someone of that size.
Well, they don't care about channels bigger than that. They don't care about channels with millions of people. There's been this whole thing recently, as I'm sure you have noticed in the YouTube culture, where people have been commenting about how YouTube has been age restricting videos from channels with millions of subscribers, and how the creators can't get any answers out of it, and how the answers are inconsistent, and how YouTube will say, oh, it is age restricted. Oh, well, it's not. Oh, it is. Oh, we're going to age restrict all the things, including Markiplier, and so forth and so on. And how these creators with 2 million, 5 million subscribers can't get answers from YouTube. YouTube doesn't care about these people. They don't care about any of us. They don't care about PewDiePie in the end. They care, at least these days, they care much more about corporate media. They care about NBC and CBS and ABC and all the old media. And they don't care about independent creators, I don't think, really of any size. I think that they would let PewDiePie go, and they wouldn't really think too many times. They wouldn't really think that much about it, to be honest.
Well, I guess they could anoint another PewDiePie to replace him.
There you go. Exactly.
Well, I'm certainly nowhere to be worrying about that with my, what do we have? We have a meager 24,539.
For the moment, my friend, you will grow into a great big channel. I have no doubt.
Well, this isn't bad for
it. Only took me 5 years, so you're ahead of the curve.
Yeah, it's only been 3.5 months, so I can't argue. But the curve definitely dropped off after Depp and Heard, but I haven't lost a lot yet, so I'm grateful for that. The growth slowed, but I haven't had any major drop-offs yet.
Yep.
Even had a direct stream, and I gained a net 15 off. I gained net 15 off of that one.
Aren't you lucky?
Because Andrew Legal Mindset, I think he lost like 200 subscribers his first direct stream. Like I had like a net gain of 15, so I'll take that. But it's a fun little time. It's been good getting to know people and doing the grift and just doing the thing and as long as the YouTube lets me keep doing it, I guess I'll do it.
Yeah. And I love talking about stories. I got quite a couple stories coming up today. Earlier today, I posted a story regarding the credit card code that was just approved by ISO. So there is now a new credit card code that's been assigned for gun stores and ammunition stores. So previously, credit card transactions that occurred at gun stores operated under a more generic code, like a sports shop or generic merchant or stuff like that. So now the credit card companies just got approval from ISO for a credit card merchant code specifically for gun stores and ammo stores, which now makes them eminently more trackable. It also creates a bit of a de facto registry, because now anyone who uses a credit card at a gun shop is suspected of owning. It creates the ability of private industry as well as governments to monitor, restrict, tax, whether through fees or otherwise, forbid gun transactions. So something of concern to Second Amendment advocates. And then in about an hour and a half, I'm posting a story regarding the student loan thing from Biden and how there might be some legal challenges that are possible on all that. And then I've got
if I can get in on that
stories.
legal challenge, I want to be part of that.
I got 2 other stories posting today. So I got 4 stories already scheduled for today. So you can check all that out on my channel on civil law.
As someone who gave well over $1,000 a month for 13 years of my life, including the IMF bailout of South Korea, where in 24 hours I watched my money on the exchange rate literally decrease by half. I have zero sympathy for people that signed their names on the bottom of on the dotted line to get loans and don't want to repay them. Trigger point.
Yeah. Well, you can look forward to that video that's posting at 11 o'clock Central.
I want to know what else you got going on, Kurt.
Other stories today. I've got a firefighter from Texas City who was denied qualified immunity because the firefighter tried to arrest EMS for not being licensed, and he doesn't have power of arrest. So there was that case. And then also later today, I've got an interesting one. An elected official was just barred by a New Mexico judge from ever holding any elected office ever. Because he was a participant in the January 6th events. And the court said that he was disqualified from holding offices under the provisions of Section 3 of the 14th Amendment. So we're going to be covering that as well today. So those are the 4 stories that we got coming on. And plus this evening, probably at 5 o'clock, I'm going to be doing another live stream in which I'm going to be recording more stories for tomorrow. So looking forward to all those things.
Wow, you're a busy beaver.
I'm trying to be. I mean, I'm taking this as seriously as I can as my new full-time profession. So good times.
So we're still about 4 weeks away from the Texas bar results.
Yeah, something like that. Last time they told me, they said sometime mid-October. I don't know if they gave a more specific dates. I haven't seen one. So sometime in October is when they said. So yeah, we'll see.
Well, cool. Looking forward to hearing the results of that. And you've got all this good stuff going on.
I'm nervous about it. I'm not going to lie. The first time I took the bar exam in Virginia, I felt really, really good about it after I took it. But this time I felt much more nervous about it because some of those essays were just absolutely brutal.
I mean, I think the essays are, you write your name on it, you get points.
Yeah.
You identify a few points, you get a few more points, you identify the issues. They always have that one that was the additional, like the test category. I had 2 games categories on mine. That pissed me off.
Yeah. It has been reported that the bar exam included both a regular rule on the essay on the rule against perpetuities and the uniform rule.
Oh, you had a rule against perpetuity. You had 2 perpetuities questions?
It has been reported that the essays included those things. Yes.
Oh,
so fun.
Yuck. Well, as one of my 80-year-old law professors said, I still don't understand the rule against perpetuity, so I don't expect you to do it. 2 on the same on the same test. Yikes. I had zero confidence. I still have no idea how I'm sitting here with a law license, because no matter how I added it up, it didn't come up to a passing grade. So whatever their tweaky matrix is, because I took the bar exam, and then 3 days later I was on a plane here to Korea, and then I had to go back in October for the swearing in. And when I got the results, it just didn't add up. I called them 5 times. Are you sure? Are you sure I passed? And like the 5th time, they're, yes, would you please stop calling us? And to this day, 27 years later, 27 years later, I still have a recurring nightmare that I show up for the swearing in ceremony, and the Supreme Court of the state of Utah looks at me and says, "What are you doing here? You're not on the list." I still have that dream to this day.
Nice.
Or the other one, I still have there's another law school where I show up. I've gone to class every day, the entire semester, and I show up for the exam, and I'm not on the exam roll, and I was in the wrong class the entire semester.
Nice.
Have you purged yourself of law school angst in your life?
Usually when I have that dream, it's about high school. And I forgot, and I think that I failed something that means that my college degree is going to be stripped away and my law school is going to be stripped away because I didn't complete some course, or I'm re-enrolled in high school to try to pass some course to try to like sneak one by. Yeah.
I was traumatized by law school. It's because I really didn't. Well, as has been on every single report card since I was in kindergarten, capable of better and or more work.
Wow. Nice.
Well, I mean, I live in the top of the Rocky Mountains in northern Utah. When it's May, and do I want to be in NAFTA class, or do I want to be on the golf course or riding my motorcycle up the canyon? NAFTA is a distant third.
I appreciate that.
When your professor looks at you and go, "Oh, when you come up like 2 weeks before the test, you show up for class, and I thought you dropped this class." No.
Wow.
Yeah, well, the guy in the study carrel next to me in the library had the equation C equals JD on the wall of his study carrel.
There you go. I like it. Yeah. What do they call the person who graduates last? Right. Yeah.
Well, there was one guy that he was my target. Like, okay, if he passes the bar and I don't, the only option is self-deletion. but I passed, and I guess he did too. Yeah, I wasn't a stellar student, so I still have these recurring nightmares because it was such a traumatic point in my life. That's why I will never, ever, ever, ever take another bar exam as long as I live. And bless you for having the fortitude and courage to do that.
Oh yeah, well, if I pass, then I have to decide, like, do I want to go to California and take that just for the lulz at that point? And it's like, what other exams can I take that might be interesting? So we'll see. But yeah, it was a lot. I did a bit of a review on my channel about the experience of the bar exam. The essays were just particularly brutal. I thought I did really well in the multi-state. So we'll see. But man, I tell you, it's like it was a rough 2 days.
Did you do the whole Barbary thing again, or the Kaplan
I did.
Again?
I did a different course which just did MBE questions. So I just did focusing on MBE questions, like, well, because that's going to teach me the substantive law again, and then it's like and then on the essays I should be okay. So we'll see if that plan worked.
Prototypo says, "Are you naked too?" No, never naked in the dreams. Those are the high school dreams. When I'm on the bus naked, I'm like, holy crap, I forgot my pants. Those are the recurring high school dreams. What was it? Oh yeah, me thinks you were both different kind of students. All right, I've told you what kind of student I was. I'm gonna say, Kurt, you were the guy that not only read the footnotes, you actually read every case that was in every footnote.
I didn't go that deep.
We had one girl in our law school. That's what she would do. She would like literally read at least every case that was mentioned in the footnotes, and sometimes the cases that were mentioned in those footnotes.
That's a lot.
I just ignored the footnotes entirely.
Yeah, that's a lot.
I relied a lot on the upperclassmen. I mentioned this I think it was with Nick the other day. We had a constitutional law professor who, of course, sold the textbook that he wrote on constitutional law for a few $100s.
That's what it does.
And it was called "To Chain the Dogs of War." And I think he was one of the chiefs of staff for McGovern, I believe. But
that's an interesting legacy.
Talking with the upperclassmen, like, how do I pass this con law test? Just say as many times as possible, the president doesn't have the authority to declare war in your essay, and you'll do fine. And it was correct. That's how I kind of got through law school, is just relying on upperclassmen to do things.
No, law school was about me trying to just do everything that was offered to me. So I did law review, and then I started my own law review, and then
civil law wrote the footnotes.
Yeah, I wrote the footnotes, and some.
You started your own law review?
I did. I was the founder and first editor in chief of the Intellectual Property Journal. So yes, I started a law review. So fun.
Geez, Mr. Overachiever.
Yeah. Do what I can. And
wow, that's pretty impressive.
Thank you. I was on moot court mock trial. I was doing like these certificate programs in IP and litigation. So my thing was just about cramming as many additional things into my schedule as possible.
I did the moot court because there's like, we need people to do moot court. Who wants to spend a week in Denver? Like, oh,
not so bad, right?
Me, yeah. We had a pretty good team though. We did pretty good.
I enjoyed it. I miss it. I miss formalized debate. I do miss it's one of the thing I probably miss the most from all of schooling is debate from high school is debate. Yeah. I miss going to various schools. I miss getting into the van, before the sun rises and coming back after the sun sets and going and participating all day in these formalized debates with rules and things. And sometimes, like with various forms of debate, sometimes you don't even know what side of the issue you're going to be on. So you have to prep for both sides of the issue. And I do miss that. There's no real adult equivalent, which I always found to be a bit annoying, because if you want to play basketball, right, you can play basketball. You can play in a sports league, or you can play in a pickup league or whatever. But there's no real adult equivalent for high school debate, and I do miss that formalized structure. So, yeah.
Well, it's like people would ask, did you get in fights in high school? It's like, I had 2 letters in high school. I lettered in choir and debate. What do you think?
I lettered in debate. Which I always thought was mildly hilarious.
Yeah, me and three of my friends, we were the first people. We entered the school. It was a brand new school. We were freshmen in a brand new 4-year school. So we were the first group to letter in debate. And it was like, I don't think I'm going to buy the Letterman jacket. I'll just take my letter and put it in a box.
That's what I did.
But it's like, you lettered in choir and debate, you little fucker. Yeah, that was me. Then after that, I enjoyed my time. I came back. They brought me on and hired me as a debate judge, which was kind of fun.
Mm-hmm. Yeah, it is fun.
But yeah, I kind of do miss that, because I like to argue. That may have something to do with it. Someone asked if you were a Libra, or you're a Capricorn or a Virgo.
I don't really buy in the whole. I don't buy in it.
Well, Mr. Upper Torso does. Flux says it's called Congress.
Congress is good.
I bet Jeff has a beautiful singing voice. Hey, Kurt's got a rap album, so
I'm working on it perpetually. Yeah.
So are you a goat or a sheep? Why would you ask a question like that? Oh, crud. Well, folks, we've been doing this 2 hours and 41 minutes, and we're coming up on midnight here. And I still have the last episode and a half of House of Dragons to catch up on before I go to sleep. So that's what I've got to do.
Okay.
It was great to have you pop in, Kurt.
So if I could ask you to come check out my channel,
Absolutely.
Uncivil Law, the descriptor is right over here. The name of the channel, Uncivil Law. Check out my channel. If you're not already subscribed, please subscribe. I would appreciate it. I appreciate
several times throughout today.
Yes, and I've got 4 stories posting today, plus a live stream. So fun times.
Well, it was super fun to have you here. Just tomorrow, what am I doing? Like tomorrow, we're doing. Oh, tomorrow's going to be fun. Australian criminal folk heroes, Chopper Reed and Ned Kelly. Okay. Ned Kelly was like the original Iron Man. He was in the 1880s. The guy and his gang, they made suits of iron that weighed like 100 pounds, like full body armor suits, and then they just went on a crime spree. Like they were like the Australian outback version of Killdozer guy. And Chopper Reed, who is a Robin Hood character, he robbed and murdered a bunch of drug dealers and criminals and baddies, but he was a softie. His friend crossed him. He shot his friend in the leg and then took him to the hospital. And then later they went on a comedy tour together.
That's nice.
So Chopper Reed. So we're going to do those 2 characters. Thursday, I've decided I'm going to start doing like once a week. You may have seen the post in the Twitter. Once a week, I'm doing bits and pieces of the O.J. Simpson trial.
Yeah, I've been seeing that. It's interesting.
Yeah, that was my 2L, the last semester of 2L summer, and then the first semester of my 3Ls when the trial was going on. So we're just doing it to compare and contrast how cameras in the courtroom and arguments have changed between then and now. And we're starting the defense arguments on Thursday. Friday is just a dump of horrible stories that I can rant about for a while.
Excellent.
So that's what's coming up for me. And hey, if any of you are here and you haven't liked me, please like me. I need the validation. I now have more likes than viewers, so that's pretty cool. Yeah. But I still think some of you haven't liked it, so hit that like button. Hit Kurt's like buttons on all of his videos and subscribe to him. Subscribe to me. That would. Oh, I see some of you have since we started, so I appreciate that. Mods, I have the greatest mods in the world, and some of them I believe might even be some of your mods. I certainly have the best chat in the world. Sorry, you have to settle for at least second place in the chat. You guys are great. Thanks, mods, for doing your thing. And thanks for all of the super chats that came in today. It's always appreciated. Never required, always graciously accepted, because y'all are awesome. And with that, I guess that's all I've got. Hang around for just a quick second, Kurt, and we'll see all of you guys tomorrow. Same bat time, same bat channel. Don't forget to check out Kurt and subscribe to his channel and watch all of his releases. We'll talk to y'all later. Until we meet again, enjoy your legal vices. I'm out. Bye.